there is some kind of a merger of thoughts. So,
in fact, I noticed that at the time when the matter was referred, attorney was appearing then for the state of Tamil Nadu. So your submissions are recorded by Justice Mishra's referring order.
I appeared for private party, but the court has generously said I have appeared for the state of Tamil Nadu.
Oh.
Doesn't make a difference at all. The stand is the same.
Stand is the same. Who will be taking a contrary viewpoint? I think
appearing state of Tamil.
Right.
My turn will be after Mr. or
we are not aware of that sequencing, but whenever
we'll take a call.
It's your lordship's call.
We'll take a call. After the parties in the main matter have argued, then we can hear whoever is supporting on the side.
that is after that, hear the other side.
My lords are trying to determine is there another side or not.
I'll be arguing for Chinnaiah. Supporting
You are supporting Chinnaiah. That's good. Mr. Ganesh, are you supporting Chinnaiah also? That's all right. Therefore, you are saying that Chinnaiah should be reconsidered. So apart from your learned friend, who else? Right. So at least we have some contest then. That's very important because we must have two perspectives before.
Tamil Nadu also.
That's all right. We are on who says Chinnaiah need not be reconsidered because we must have some contest and somebody from the other side. All right. So that's good. We have therefore we have counsel on both sides. Right?
The Tamil Nadu wants
as every council gets up, we'll ask them which matter they're appearing in. So we have that clearly before us.
the Tamil Nadu
Parties and then interveners first, so that we can
So first the parties and then the interveners. I think that should be correct.
so that we can adjust.
Yes,
Tamil
Mr.
Nadu also wants Chennai to be revisited.
Yes, yes, of course. We've seen the referring judgment, so we know that. Yes, Mr. Advocate General.
Or to start again, my lord, the first core issue, my lord, which your lordships would examine is the efficacy of measures taken under the constitutional provisions framed for eradication of inequality in over 76 years of our independence.
It is slow.
And the second issue, my lord,
It is slow.
that's right, my lord,
The efficacy of measures adopted
by the states for eradication of inequality in over 76 years of independence. So that's the first. And the second is the interplay of the constitutional provisions regarding the powers, my lord, in the federal structure of our country. Interplay of the constitutional provisions, my lord, regarding the powers in the federal structure for identification and implementation of the measures so taken. I can repeat it, my lord.
That's okay.
Yes. The interplay of constitutional provisions regarding powers in the federal structure for identification and implementation of the measures so taken. But before we go into this, my lord, what is very necessary to understand is, very briefly, the concept of reservation, my lord. It obviously has two perspectives which are very strongly entrenched in our social and legal fraternities. The first perspective, of course, is of those who believe they are entitled and the second perspective which most certainly needs attention of this honorable bench, is of those who are actually in need. Lord, before I go any further, Mulad, we have to understand that reservation is no benevolence. It is not an act of benevolence by the entitled to the needy at all. If at all, it is compensation for centuries of suppression of the needy, if at all. And, my lord, nothing would correct itself on its own. So therefore, the established requirement is that of an affirmative action, what we are addressing your lordships on today. The only way to provide succor to the needy is the affirmative action on which we will be addressing your lordships. Why this has come about to be, my lord, is not far to see, especially in our country, where the caste system, my lord, has prevailed for centuries, we are all aware, and there has always been a deep divide, and the ramifications of that have resulted, my lord, in certain castes being marginalized to a status of despair and almost of non-existence in the social fabric of our society. What has come to those who have been marginalized, in the generic sense of the word, we can call backwardness, because that word, my lord, will occur repeatedly as we address your lordships and refer to the judgments. In a generic sense, that word is backwardness, as opposed to what we never talk about and take it for granted for the people who have it, is forwardness. Forwardness is taken as an entitlement by those who have it, but what we need to really look at is the backwardness. And the backwardness, my lord, in my humble submission, can be faceted in many ways. It being social backwardness, or economic backwardness, or educational backwardness, so on and so forth, my lord. We can have a debate on this alone, that for those who suffer, what is the kind of ignominy and backwardness that they are victims of. But the issue, my lord, is the cure. We've been striving to find this cure through a series of judgments, through a series of legislations, through a series of executive decisions. But obviously, my lord, because we stand before your lordships to address again on this issue, means that much needs to be done. And what has been done is most certainly not enough. Lord, if we were to put it very simply, though not a panacea for this ill of society, cure definitely is equality. The only thing by which these lines can be blurred, and we have a society that the Constitution envisages the cure is eventual equality. Now, my lord, to achieve this, we must understand, however overrated the issue of reservation is, but reservation is only a tool. Reservation is only a means to achieve the end of the sacrosanct ideal, which is equality. Now, as in everything else, my lord, a tool is of no consequence till in the hands of a good sculptor. Merely providing for reservation is not the answer. A tool has to be used for the purpose that it has been designed to achieve the result that we seek to so desperately achieve for our country, which is equality. And this implementation can be done most certainly through law, definitely through the executive action of the state, and also through social debate. And the constitutional framers, my lord, had this intent very clear in their mind while providing for reservation, that the only reason which weighed with them was the realization of the disparity that existed, the disparity that was hard to ignore, the disparity which was in the face of the country when we became independent. And the effort was to achieve Bharat, India, where eventually everyone has a right to equality. So, my lord, Article 14 is what we strive to achieve, and everything else thereafter, in part 3 or the parts thereafter, has been designed to achieve that end, is equality of opportunity. It is not a case where we are before your lordships to say that somebody who has not played could definitely not have won. That's not the case here. The case here is, did he have a chance to play? Did he have the opportunity to play? Did he have the means to play? And did he even have the path to the ground where the game was played? The answer is no. When the privileged play the game and the top amongst them win, we fail to think about those who couldn't even make it to the playground because of the inadequacy of the means that they do not possess. So therefore, my lord, I'll read the preamble, but what comes out of it is that equality of status and opportunity is the hallmark of our constitution. And the assurance that we propose to give it is an assurance of dignity. Because no opportunity or status without dignity is complete. You cannot give opportunity as charity, because charity takes away the dignity. There have to be provisions enacted and implemented in law to achieve this equality of status and opportunity with dignity. And this is what can effectively eradicate what we call backwardness. Lord, there is a reason why, as I said, after 75 years of independence, we are still struggling to achieve this goal. It's easier written than implemented. The words have been there. The intent has been there. The implementation has been there. But there is not much achievement to show for it, because what has been precipitated by centuries of suppression was not expected to go away in a decade. It wasn't. As some people might say, 10 years was the limit set for reservation to achieve what centuries had caused. Can't be done. We are very well aware of it, Mullah. But let us not marginalize the efforts that we've made, but most certainly we are not there as yet. And this matter, Mullah, is yet another effort to convince your lordships to lay down a law which will eventually help the benefits of reservation to percolate down to the strata who need it the most. The reason is, my lord, that a class of people belonging to varied castes, these are two different concepts, my lord. As we go along, we'll obviously dwell on them. That caste and class are totally two different concepts. A many number of castes in India, my lord, are stuck, unfortunately, in a self-deprecating cycle of occupational drudgery. Even today, there is one thing in inheritance which a lot of castes get, which is their occupation. Scavengers, sweepers, cobblers, blacksmiths, what they've handed down in inheritance, legacy, and estate to their next generation is an occupation which will never allow them to come out till aided by what we call affirmative action. The reason is, Mullah, that there is a condition. We are all, as human beings, victims of conditioning. We are conditioned to believe that everything is all right. We are conditioned to believe that things are the way they are because they are meant to be. Oft heard dialogue is, my lord, if these people were not to do this job, who else will? And that is the reason these things should remain as it is, but that definitely is a mindset we need to shake ourselves out of. There are no ironclad barriers, my lord. Should keep the backward confined to their backwardness just because what they do is what nobody else would do, and their not doing what they are doing will not suit the entitled. That is the answer. We have to change these prejudices. We have to change the mindset. The problem is the resistance. The problem is the resistance to change that mindset. The problem is that it seems like a huge shift in a societal mindset to steer ourselves away from it and think that why can everybody in the society not be equal? And as we go along, Bullard, the core issue here is not only the advantaged and the disadvantaged, but the more advantaged and the more disadvantaged within the disadvantaged. That is the issue that we are addressing, Your Lordship. Undoubtedly, Mulad, the change has to come at the grassroots level of society. Undoubtedly. What happens in the mind is controlled by exposure, mostly to what is taught in each and every household of this country. That has to change. But it still does not take away the obligations upon the state to aid and assist this change, which either in the form of bringing about a law by the legislature, decisions of the executive, and more important than anything else, the laying down of the law by your lordships, which will eventually bring this. Because once your lordships lay down a law, the acceptance of a proposition goes up tremendously. Because your lordships say so, there is a dispensation of the public to follow the law. So from either of these three wings, if an assistance and aid is coming, in achieving these results, it is more important than the other. We cannot downplay any part of this. Because, as I put it, Mulad, normally when we argue cases of reservation, a very common plea is raised that, my lord, I have 99% mark. I am being ousted by a person who has 56% marks. Is that fair? Yes, it is. It is fair because the person who has 56, he never had the means to be brought up in a family that you've come up in. He never had the means to go to a school that you went to the college that you went to, and to the competition preparation that you went through. And today, 99 is not your achievement. It is a conglomeration of all the factors that you've been through. That 56 is in spite of the factors that that child has been. He has today reached 56, starting from 0. Your ride has been of an airplane from your birth. This person has walked his way to 50. That is what we need to understand. And the person who got 56 had no access to a dignified life. He was brought up in a neighborhood which did not give him any access to good education. What to talk of employment? And eventually, my lord, what are we striking to achieve here? By way of employment, we are wanting to make that person a part of governance. He has to feel that I am a part of running this country. I am a part of aiding the growth of this country by getting employment. That is why we'll mostly be, my lord, on 16.4. So for that purpose, the obligation of the state is best discharged by affirmative action under 15.4 and 16.4 to give this person who is backward access. We have to give him at least an opportunity. I will go as far as to say, my lord, that the old phrase that you can take a horse to water, you can't make him drink. We will have to make an effort to make that horse drink, because that horse has never seen water. That horse does not know that it is this water which will eventually quench his thirst for becoming a part of governance. He wants it, but he doesn't know how to get it, because he's stuck in a cycle of occupational drudgery, which the society doesn't let him come out. Though opportunities are available, but they are not being capitalized because of, I would not say the intent, but the effectiveness of the implementation is lacking. But eventually, if we all agree on this, that the goal is equality of opportunity, then what we urge before your lordships today is that measures need to be taken to make this goal not illusionary or formal, not a mere provision on paper. These goals do not have to be illusionary or formal, but actual and effective. They have to be end-oriented. If I can put it simply, they have to be end-oriented. Results have to show. And in this, there is a heavy onus upon the state, either at the center or the state level, for achieving this equality of opportunity. But this implementation has happened in phased manners. There have been amendments in the Constitution. There have been large number of executive orders, memorandums, laws, legislations brought out by various states. One of them of my state is under challenge before your lordships, from where this litigation arose. Just to put it briefly, though it's not a relevant issue that your lordships would be deciding. In Punjab, we brought out an act in 2006, where out of the posts which were reserved for the scheduled castes, 50% of the posts were reserved for Valmikis and Mazhabis.
That was your first circular which you brought out.
Not this, yeah. No, this was not circular apart. This was the legislative act which was under challenge.
The circular preceded the
Yes,
because the
yes.
circular had been struck down
That's right,
actually
that's
for want of legislative sanction.
So therefore, the legislation in 2006 and section 4, subsection 5, reserved 50% of the posts for Balmiki, Sikhs and Mazhabis, and there is a twofold implementation which saves it from the vice of discrimination and reverse reservation and reverse discrimination as we know it. This reservation in the 2006 Act was done on a twofold check and balance. One, that this reservation was limited to 50%, which in the development of law has become the Lakshman Rekha, which we are all advised not to cross. And the second check and balance was that this was implemented on a preferential basis. So, my lord, as I would say, this was not an act of exclusion by any standard. By any standard, what Chinnaiah, my lord, seeks to say is that this would be an act of exclusion. No. This was, if at all, an act of inclusion of those who were the most backward of the backward, to bring them, if not at par, at least up from where they stood.
Advocate, when you said that it was implemented on a preferential basis,
That's right.
Can you elaborate that? How is it implemented on a preferential
Yes,
basis?
Lord. So suppose there are 10 vacancies for scheduled castes in a particular year or a particular recruitment. 5 were reserved for Balmikis and Mazhabis
Right.
if they were available. And if they were not available, it was to go to SC others, which are Ramdasiyas and other scheduled castes, which were available. So in every recruitment, one would ensure that 10 scheduled castes definitely came in. But at the first instance, the right of preference of 5 of those 10 was to go to Balmikis. And
There was no carry forward for
carry forward was Bulot en bloc.
for the SC together.
Yes.
But not for the
Not
Valmikis
for-
and the
no,
Mazhabi
no.
Sikhs within the SC.
They were exhausted within that recruitment.
Yes.
So therefore, if I can put it Bulot in cost-effective way, this preference-based reservation was not at anybody's cost. It was not that if they did not get it, nobody would get it. If they did not reach the Mulot cutoff for getting that reservation, a scheduled caste only would get it. And your lordships are right, those scheduled caste vacancies were to be then, in common law Mulot, as we all know it, to be carried forward and not counted towards reservation, this, that, and the other. All those parameters were to follow. It was not that they would either be converted to general or not be filled up and left vacant. There's nothing of that sort. So therefore, that is the core bullet, that if you cannot even as much as give preference to somebody who's really needy, without that being at the cost of somebody, and that act of the state government is quashed, is that correct? We are here to urge that before your Lord. Now, my Lord,
Actually, Mr. Advocate General, there is an element of exclusion. I mean, let's not gloss over it. The point only is this, that because, the same exclusion which applies to reservation per se
of excluding merit, as we all put it.
Posts are reserved.
Yes.
Once posts are reserved for a backward community, there is necessarily an exclusion of the forward communities in competing for those posts, right? Yet our constitutional jurisprudence permits it. Why? Because we treat equality as a substantive equality, not formal equality.
That's right.
Therefore, post N.M. Thomas, we have now developed jurisprudence to the effect that reservation is not really a breach of equality, but it
aid of equality.
But interestingly, the same argument which applies for reservation for the backward communities, the block, the backward versus forward, would also apply within the backward community, because what now we are really doing here by the measure which the Punjab legislature brought about was this, that within the reservation of seats for the scheduled castes, 15.5%. We'll take it for a moment, I mean, just as a benchmark.
That's right, as a ballpark.
Out of the 15.5%, which falls within the overall 50% cap, 50% of the 15.5% is reserved for the Mazhabi Sikhs and the Balmikis.
That's right.
Right? So, to that extent to which the reservation is exclusively carved out for them, the other backward castes cannot compete for those posts which are set apart from them. So, in a sense,
in the first instance,
in a sense, it is in that sense exclusionary. We can't gloss over the point that it is exclusionary.
We can't.
The only question really is this: can that exclusion not be justified on the same yardstick that we have applied for the exclusion in the backward versus forward context?
But if I had to put it very
because within the backward, within
Yes.
the backward communities, within the scheduled castes, is there anything in constitutional jurisprudence which restrains the state from saying that I'm not deleting a community from the list of scheduled castes which has been designated by the President under Article 341 or 342, but within those communities, I am now making a classification that certain communities are more backward and therefore in greater need for protection on the same touchstone of substantive equality. And if that can be done by the state in carving out certain posts out of the competition of the general community, then why can't the state do it within the backward communities? That's really the
absolutely
point. But there is an element of exclusion, we must face it. I don't think we can gloss over.
What this entire example that your lordships have given is based upon a very simple word, which is relative backwardness. once we concede to the argument of relativity in backwardness, and it is the backwardness vis-a-vis the forward which brings them into the 50%, and it is the further more backwardness within the 50% which gives them the reservation within the reserve, then this argument has no problem.
Now, Chinnaiah said, Chinnaiah's whole rationale was this, that the power to designate communities as scheduled castes and scheduled tribes exclusively belongs to the president and now therefore
Absolutely.
parliament. For instance, in Milind, we
That's
have got all those Palghat Jila Thandan, Milind
That's-
Katware, which came from Maharashtra.
That's true.
It is not open, for instance, for the court to say that though this community is designated as a scheduled caste, another community is part of the designated community. You have to take
Can't
the
do.
list. That you can't do. The
Can't.
court, our court is that jurisprudence is now very, very well set.
That power has been
You
reserved. for
can't
the
tinker
parliament.
with the list.
That power has been reserved for the parliament, remains so.
That's right. But the argument which seems to have found favor in Chinnaiah was this, that if that is so, then the state cannot classify within the list of communities which are designated as scheduled castes, because to make that classification would amount to an exclusion of some communities within the scheduled caste. That seems to be the logic of
Yes and no.
Chinnaiah. I mean, very simply
Yes-
put, that's really
yes
the
and
heart
no,
of the
Mulad.
controversy.
Because Chinnaiah, in my humble submission, was a plane which took off from the wrong runway.
And your argument would be, I guess, that you're not deleting any community from the list which has been designated by.
There's no exclusion.
There's no exclusion. But within the quota, you are saying.
Why should not there be exclusion? According to you, amongst a particular category,
Please.
some of these subcastes have done better. They are the forward in that category.
Absolutely.
They should come out of that and compete with the general.
There
Why
are-
stay there?
There are
And let the remaining who are still backward,
yes.
within the backward, let them go and have the reservation.
Lords are absolutely right, but there are two ways that this whole
But they have
concept.
achieved
Yes.
concept of
That
reservation.
was the
They should
aim.
move out of that category.
That is the aim.
Yes.
And if the aim is achieved, then the purpose for which the exercise was taken should come to an end. Because nobody, my lord,
No, aim is achieved according to you for certain subcastes
Yes.
in that particular category.
within. My lord, so
Within.
that's why I'm saying it works
So,
in two ways.
They have achieved, they should come out and the remaining should get that benefit.
Yes. Now, my lord,
No, his argument
what
appears
your
to be-
lordships are suggesting.
Your argument appears to be amongst the backward, there are more backward.
Yeah.
Therefore, they require a more special treatment
Yes,
than
yes.
the backwards.
Yes. But
Actually,
what Justice Nath is suggesting
And
is
your,
the ultimate.
Advocate General, your argument also would be at two levels. One is the equality argument, and the other is the federal argument, which you also made. One, the equality argument postulates that it is open to the state to classify within the scheduled castes by identifying those who are really, really within them in a state of relative marginalization.
Absolutely.
That's the substantive equality argument. And if you can do that between the general communities and the
Absolutely.
backward castes, why can you not apply the same principle?
The same
to the
principle
backward?
there.
The second, of course, is the federal argument,
Yes.
that every state within the nation is peculiarly conversant with the conditions of the castes and communities which are prevalent in that state.
So right.
And therefore, what Parliament has done is to designate castes and tribes for the entirety of the nation. But that does not take away the power of every state within its own territories
Yes.
to say that, well, these are the communities within my state
Yes.
who are particularly marginalized
Yes.
and are worthy of special attention.
Benefits, as they
and
call them.
special benefits. And there is nothing in the constitutional structure to prevent the state from doing that, because it ultimately owes responsibility to its own residents.
Absolutely. But now, what Justice Nath was saying is the ultimate argument, which they rightly note
You must
is
have
for the
done some-
parliament.
You must have done some exercise.
Yes.
In identifying.
In identifying the backward within the backward.
Within the backward.
And
like
because
you did
of that-
Madhabis and Valmikis.
Absolutely, Mulad. Mulad, now the issue.
What are the parameters or the considerations you've taken into in identifying?
Various reports, Mulad, which show that those people are two things. One, they continue to be backward, and or in spite of being what they are not adequately represented in services under the state. These are two parameters. One, are they really the backward within the backward? Two, whether they are backward within the backward or not so backward, or forward backward or backward forward, they are still not represented. So there is something lacking somewhere in the matter of policy. And that is what the state seeks to address.
Now, Mr. Advocate, do we have some population data on what is the total population of SCs in Punjab? And what is the population of the Balmikis and Mazhabi Sikhs within that group of
That's right.
SCs?
We do. They're all statistically available. But why I am not stressing upon that is because the reference to your lordship's primarily
It's not a numerical argument. It's not a numerical argument.
It's not a numerical argument. The argument is, first of all, can you do it? As Justice Nath has correctly put, can you do it? If you can, and the answer is yes, who is to do it? Parliament, state, executive, legislative. And if who is to do it is determined, then how that state is to do it, how is not the issue before your lordship.
Sort of laid down the jurisprudential framework in the first part of your submission.
Please.
Now, why don't we go into the nitty-gritty of it?
Yes.
Show us the statutory provision.
I will come to that in just 2 minutes.
Then we look at Chinnaiah.
Yes.
And why we look at the law before Chinnaiah and after Chinnaiah. Chinnaiah is 2005. Chinnaiah has then been overtaken by a lot of law on the subject.
Absolutely. Now, my lord, why I'm trying to distinguish that argument is that Chinnaiah proceeds on the basic premise that exercise of power for the purposes of identifying the backward within the backward
is only of Parliament.
Is only of the Parliament, and any exercise by the state to that effect tinkers with that power. What Chinnaiah has possibly failed, we'll go through the judgment and see if I'm correct, is that 16(4) is an independent provision which has to be exercised by the state, either center or the state government. The powers which give the enabling provision, an exercise to be conducted by forming an opinion, is totally within the legislative domain and the executive domain of the state government. There, Parliament does not figure. So the distinction is, my lord, for instance, that there is a, my lord, room in which benefits are being provided. In common parlance, 341 and 342 are the pass with which you get into the room. That's all. Are you entitled to be in the room or not? The president decides. First list, which is a one-time exercise by the president, that whether you're entitled to be in the room or not. Then, as common culture goes, my lord, we have VIP passes. So then the Parliament decides that whether who's in the room is entitled to be in the room or to be displaced from the room, or who's outside can be given an entry into the room. There are two different exercises. One is a one-time exercise by the president. He issues an order in 1950 for Punjab, let's say, that these 26 castes are entitled to be in the room for the purpose of benefits which these scheduled castes are entitled. Understood? Thereafter, that power is taken away from the president and vests totally in the Parliament, that whether those inside, as your lordship put it, are entitled to remain inside any longer or not, and whether those outside have reached a stage where they now become entitled to be inside. So what is very interesting is that even the Constitution in 341 and 342 accepts this exercise to be a two-way street. The power of the president is a one-way street. Once you issue an order, in common words, you become functus official. You cannot touch that order on the executive side anymore. Once that exercise has been done, then forever, the Parliament will remain vested with the power to legislate,
include more communities,
to include more, or to exclude. So my lords were right. That power to exclude, that you attained that forwardness, which does not anymore entitle you to be called as a backward class. You have to exit the room and make place for other people, as your lordships have put it, my lord.
Taking further the concern expressed by my learned brother Justice Vikramnath, if within a particular backward class,
Please, my lord.
certain castes have reached that position and they are on par,
Please, my lord.
and as he pointed out, then they should move out.
They should exit and
Yeah,
make
but then that is again for the Parliament to.
only for the Parliament. Only.
But then
Now,
No,
that
since,
is what I was
we are deciding an important issue.
Please, Milord.
Just giving a thought for consideration
Yes,
of all of
Milord,
this.
Milord, are absolutely right.
Now, what happens? Person from scheduled caste or scheduled tribe gets into IAS, IPS.
That's right.
Once he's an IPS, IAS, IPS, IFS, his children no more suffer the disadvantages that the persons from the category who are residing in the villages are suffering.
Milords are right.
But then, by virtue of reservation, they are also entitled to get in the second generation.
Therefore,
Second,
it is
And again the third generation. So,
property only and
so-
not getting the general.
So you're,
beg your pardon? So, similarly, it's not available for schedule.
now it is, Milord, after Jarnell. Now it is. But that's again, Milord. Yes.
Yes.
So that is not the area I'm immediately coming to, but just to take the example forward of what my Lord Justice Gavay has pointed out, Milord. Who enters or exits the room? Let's put it as a two-way street. Who enters or exits the room is the prerogative of the president, followed by the parliament forever.
But you are saying the distribution of
The
benefits
distribution of the
within-
sweets and the benefits inside the
for
room.
those who are already within the room is for the state.
Yes,
Yeah,
Milord,
that's
to
what
say
you
that those who are underweight will be given a free meal. Let us take it that's the title to be in the room for those benefits. Very well understood. A person is 49, he's still in that room. There's a person who's 27 kgs who needs it far more. Are you going to treat both of them equally?
But let me tell you, let me test the argument to its logical extreme.
Please
to
do.
test the argument.
Please, Milord.
Test the argument. Can the state say that we are giving 100% reservation
No.
out of the scheduled caste only to these two communities?
No, Milord. Cannot be and should not be. Why?
Why?
Because then you are excluding. Without legislating, you have virtually done
There
what
you
only
have a
341
problem.
can
You
do.
have a problem there. Because even if you are making it short of 100%, exclusion is implicit. So you can't place it on the exclusionary argument.
Milord,
100% is an absolute exclusion.
that's true. That's true.
But 50%
That's true.
is an exclusion qua those who can't compete for that 50%
Milords are right.
within the backward.
Milords are right. Milord.
So
Milords are right.
there is an element of exclusion. So we'll have to answer it if we have to in saying that Chinnaiah has overlooked our jurisprudence, that we can't place it on this that, look, I'm not excluding. We'll have to place it on a more sound jurisprudential
Not
foundation.
whether it's preferential treatment.
What he argues is they have applied the principle of 50%,
That's right.
which is considered as a Lakshman
Milord,
Rekha for
yes,
reservation.
because in
So
institutional
there
preference,
is no
those-
complete exclusion.
There's no question.
Milord, institutional preference in medical
Even
college.
otherwise, even by providing 50% reservation for backward classes, exclude 50%
For the general
for the general community category.
That's right. And that your lordships have upheld. Indra Sawhney, Milord, which of course went into this issue in detail, said that otherwise you will be inhibited in taking up any exercise with reservation. Because if you say that you cannot do it because it amounts to exclusion, it will not be the intent of the Constitution. If you have to do it, whether you can place checks and balances on it, is the intent of the Constitution. And that 50% is, of course, Milord, a judge-made law. Where your lordships have held, let's be fair.
But I go one step further.
Please.
Is the state bound by the 50% cap while applying the distribution of benefits within the 50%? Why should we? I mean, why should we? It's very, it's otherwise very attractive. But is the state truly bound by that 50% cap within the backward? Can the state not say, look, in my state, these communities are the truly marginalized communities. I want the benefits to go to them.
Yes.
I'm not breaching the cap insofar as the general communities are
Yes,
concerned.
yes.
I'm not ousting equality of opportunity for them.
Milords are right.
But within my state, these are not okay. These are two here. Maharashtra may say or Tamil Nadu may say no, it's not two. It's 7 in my state. It may say maybe 15. Can the state do that or can they not do it? Why can't they do it?
I'll try and answer it. But when we talk about provision of reservation, let's be very clear that there is no mandate by law. There is no mandate by law to provide reservation. Therefore, 15 and 16 are enabling provisions when we talk of
That
clause
is
4 and
contrary
both.
to Indra Sawhney, my lord. I
Yes.
disagree
No,
with
no,
that.
but
Because that
we are only
classic-
developing an argument.
20,
We are only
it's-
developing an argument.
It's real.
To
it's a
provide
discussion that.
to provide for reservation, my lord, what has broadly been laid
It's
down.
an enabling provision.
Enabling
Yes,
provision.
there are 4 checks and balances.
Though Indra Sawhney says that even if sub-article 4 of 16 was not there, still the state would have been empowered to do
Yeah.
reservation because
Yes.
article
16(1).
4 emphatically states what is implicit in 16.
16(1).
Yes. That's Article 46
All
and the
equal
consequences
for all
thereof.
equals.
That you will take care of them. That is your obligation. How you will do it, my lord, then there are powers to be exercised. But there are 4 checks and balances, my lord. I can share them at the outset with your lordships, which
So now-
eventually,
Why don't we do this? Why don't we now look at the judgments and see, what is the area for maneuverability?
Yes.
What is now given?
I'll just,
Because
my
we
lord,
have
answer
7.
that question in short. So what your lordships have determined, my lord, one is backwardness, which I have submitted before your lordships is relative. Backwardness in the case of OBCs has been held to be a determinative factor, that whether you are backward or not, the state will decide. In the case of scheduled castes, your lordships have held backwardness is presumed. You cannot go into the exercise of determining the backwardness if you're a scheduled. The second factor, my lord, is inadequacy in representation in public services. Now, this is a data-based concept. Just answering, my lord Justice Chandrachud. This is a data-based concept. It's statistics. Are you adequately represented or not? So, my lord, that word can have a lot of connotations because they do not say equally represented. We've never gone into that. They do not say equally represented. It can't be that they can ever be brought at a common platform. Maybe, maybe not. The word used is adequately represented, and that opinion, again, is to be formed by the state. The third, my lord, is the concept of creamy layer, what my lord Justice Vikramnath had put it, that once you've achieved it, you still get the entitlement to remain within the backward classes or not. And the fourth, of course, is efficiency of services. That whether provision of such reservation will eventually amount to compromising the efficiency of services under 335. Because that is also your constitutional obligation.
Therefore, Indra Sawhney says that there can't be reservation in certain type of post.
Certain type of post,
Head of the department,
not beyond 50%, not without going into the checks and balances. So therefore, the exercise, not in my humble submission, is pretty comprehensive. Your lordships are right. Why a state cannot give 70 and the other state give 30 and the other state give 20? When they do it, it will be up for judicial review based upon the quantifiable data on the strength of which such a decision has been taken.
That is exercise will.
Done in Punjab, yes. I'm sure in Tamil Nadu, yes. I'm sure whichever state has done it, they are expected to and would have carried out this exercise. But that, as I was saying, my lord, a 3-judge or a 5-judge bench will decide that whether that exercise which has been done is susceptible to judicial review, and if so,
The High Court struck it down only on the ground.
yes, of Chinnaiah, only on
Namely that you cannot classify
can-
further for the
that
distribution
this
of the-
amounts to tinkering with 341. That was the entire sum and substance. And in Devender Singh, my lord, their lordships held that that may not be the correct thing. Because 341 and 16(4) operate in 2 distinct legislative spheres. They have no overlapping as far as their implementation is concerned, because, as I put it, 341 decides who's entitled for benefits, who to be given how much. Within those entitled is the exercise by the state. So therefore, my lord, my humble submission was that unless this exercise is permitted by law, if you block it, then what your lordships call will happen is the word called lumping. Then all the benefits will be lumped upon a part of the part. And the others who are truly deserving, for whom these provisions have been made to achieve the eventual end of equality, will never get it. The lords have rightly put it. IAS, IPS. Lord, even if somebody is an inspector, his family has made it. His children will go to a good school. He will be in a city or a town or an urban estate. But for somebody who's still sitting in that part of the village from where you're not allowed to draw water from the well, he's the one who needs it. You cannot allow lumping. of benefits with a certain class within a class. And if touching that class within a class is taken to be tinkering of 341, but in my humble submission, that would be an erroneous legal. And my lord, nobody intended reservation to be a perpetual concept. Nobody, not even the constitution framers felt, because we've had studies, we've had Mandal commissions, we've had judgments. Nobody wanted that reservation should remain in perpetuity, because eventually then that would mean that the exercise of reservation itself has failed. The idea is to achieve equality in the lowest time frame possible. Mullahs are looking at that.
You know, I was just going to tell you that the problem on being on this side of the bench is that clock constantly, ticks
Right.
in my face. So
I understand your lordship's point that this is definitely at the cost of some other case.
This is the core of the matter. You've laid down your jurisprudential foundation, no doubt about it.
Very well.
We can now.
Now, my lord, let me start with the statutory provision. Now, my lord, before we go into, my lord, anything at all in this matter, my lord, what is very essential?
Where do we get the act actually? You can just tell us.
The act is a part of the
We'll go to the
volume 4, page 1. My lord.
volume 4.
After the index, my lord, there is the Punjab Scheduled Caste Act. My lord, have it?
Volume 4, page 1.
Page 1. And your lordships would have the offending provision at internal page 3, which was section 4 and subsection 5.
As a first preference from among the scheduled castes.
Please, my lord.
As a first preference
Yes.
from among the
Yes,
scheduled castes.
yes. That is what I was trying to, my lord, impress, that it is not exclusion in the sense that we take it, but it is only first preference amongst the scheduled castes, and then,
And if available.
yes, then it will remain within the scheduled caste. Nobody will be denied the benefit by virtue of this. Because we need to now see who are we dealing with.
That is also part of volume 4, or you want us to take the book?
My lord, whichever way, my lord, constitution is not. My lords may have the book because the entire constitution we've not, yes, we've not put it in the compilation. in this constitution.
This is Mr. Shankar Narayan's gift to the legal profession.
This.
The good part about this is that, it has footnotes tracing the entire legislative history. So right at one point, you don't have to then flip between amending acts and amending statutes. Constitutional amendments.
It is a book which by habit every lawyer should carry in his breast pocket. I know your lordship's affection for the constitution. Breast pocket.
My courtmaster says the library has purchased this.
But Mr. Shankar Narayan gifted us with one copy, I think.
Last time Mr. Shankar Narayan had given
At 370
must have gone home, I think.
You can sign it and give it to me.
We have it on our table in the residential offices.
So, my lord, if your lordships have 366 more, it says definitions. In this constitution, unless the context otherwise requires, the following expressions have the meanings hereby respectively assigned to them. That is to say, my lords, may straight away come to 23. Schedule, my lords have it. Schedule means a schedule to this constitution. 24. Scheduled castes. Now, my lord, if your lordship would realize, this is kept in inverted commas. Scheduled caste is defined as means such castes, comma, races or tribes or parts of or groups within such castes, comma, races or tribes as are deemed under Article 341 to be scheduled castes for the purposes of this constitution. So the definition has been directly linked with 341. And similarly, in the case of scheduled tribes, my lord, it means such tribes or tribal communities or parts or groups within such tribes or tribal communities as are deemed under Article 342 to be scheduled tribes for the purposes of this constitution. So we'll straight away go to 341, my lord, because that will tell us, so the language is quite paramaterial. Lords may have 341. The only thing we will get from there is who can do it. Yeah, I mean, 1. The president may, with respect to any state or union territory, and where it is a state, after consultation with the governor, thereof by public notification, specify the castes, races or tribes or parts or groups within the castes, comma, races or tribes, which shall for the purpose of this constitution be deemed to be scheduled castes in relation to that state or union territory as the case may be. So, my lord, I'll just analyze this in a very short while. It's very clear that the authority, my lord, empowered to do this exercise under 341 is the president under clause 1. Now, when he's exercising this power, my lord, with respect to any state or union territory, and when there is a state in consultation with the governor. So this is, my lord, the consultative process which is undertaken. There is no dispute regarding the issuance of an order. And it is to be done by way of a notification, no problem. The interesting part starts after notification, and which is very germane to the present controversy that I'm arguing before your lordships. Why? Because even while defining as to for whom 341 can be exercised, it is not a monolith law. Because may kindly take note of it. When 341 itself says that it has to specify a caste as a whole, comma, races or tribes, or parts of or groups within castes. That means a caste can most certainly be split. It's evident if caste was so sacrosanct that anything would amount to tinkering with the caste, then 341 would not be couched in this language. Because the president can choose that this caste, for instance, I'll give your lordships an example. A caste is a scheduled caste in Punjab.
May not be in Maharashtra.
The same caste may not be in Maharashtra.
That's why somebody who's designated as a scheduled caste in Punjab,
Yes,
if they go to
cannot-
Maharashtra, they may not get the
They will
same
not
benefit.
take it.
They will not get the same benefit.
And
Also, at one time, there used to be territorial restrictions, which were abolished after
you can't
1976.
apply.
So even though you were designated as a scheduled caste, you could get the benefit only if you belong to that particular region in your state.
Right.
Districts.
Districts, yeah.
Quite.
Now, after 1976, the territorial division was
Has been-
done away with, but it was there until
was there.
76.
Was there? So, my lord, very interestingly, your lordships have rightly put it.
Certain tribes in Colombo district of Maharashtra
May not be.
would not be in the other parts of the state.
So, my lord, yes, that is what I was coming to. That the same caste in one state may not be a scheduled caste in the other. The same caste may be a scheduled caste in a state, but may be a scheduled caste only in a particular district of another state. The same caste, my lord, may be commonly designated as a scheduled caste for many states. So therefore, they say that all will be defined in the part to the schedule. But therefore, the definite conclusion which arises from reading this definition is that caste in itself is not an indivisible entity, number one. And under definition of 341, it most certainly is not a monolith block. It is not something which is to be taken as eradicator of birthmarks. No. You all know the birthmark philosophy, Millard, that once you become a scheduled caste, then you lose your birthmark, you're only a scheduled caste. It doesn't happen in 341. There are two reasons why. One, that as we have not already seen, a caste, once it enters the scheduled caste, may be a scheduled caste in a state or a district or more than one state. So therefore, you will have the benefits of the schedule only if you are within the definition so ascribed to you in the order issued by the president as amended by the parliament. That thing is very clear. Two, why it is not, my lord, a monolith is because it is a reversible process. It is a reversible process. Today, you can say that a caste is a scheduled caste in 3 districts of Punjab. For instance, I'm only taking an academic example. Tomorrow, you may reverse that status for one of those 3 districts also.
But now area restrictions are not possible.
No.
It's been done
The
away with.
parliament can say that this scheduled caste has, suppose it is located next to an urban center, people of that particular district have risen in affluence and have the opportunity to compete. They may exclude that district. The parliament may, in its
The
wisdom.
parliament has a power because any group of persons in that caste also
Yes, that's right, Mullah. So therefore, it's not an irreversible process. So therefore, when you are saying that even within a caste, you can create parts. And Mullah, for this, all we have to do is we'll go to the presidential order in respect of any state, and this example will be, Mullah, laid bare as to what I'm trying to say. Now, the issue is, why are they called scheduled castes? Because this word has become very generic. He's a scheduled caste. Why? Because his caste for that particular area is contained in the schedule. That's all. A scheduled caste is not a caste, as we commonly think. A scheduled caste is a person whose caste is included in the schedule for a particular area of a state or variation thereof in the manner that we have discussed.
the parliament to a particular caste from the schedule.
It can remove a caste.
That caste would cease to be a scheduled
It
caste.
can cease to be a scheduled caste. That doesn't mean he is not a caste which was backward, is backward, or continues to be backward. But if the parliament in its wisdom removes that caste, or the parliament in one context removes a part of that caste, or a group of that caste, because there's a lot of interpretation, Lords were right, given in millions and other judgments, that you can either put a comma where there are castes which denote the same category of people. They are known by different names. Or you can put a subcaste in a bracket.
That is not permissible. It can be done only by parliament. The court can't
I'm
intervene.
saying you can. You meaning the parliament.
Parliament.
The parliament can do it. That they can amend it, put a subcaste in a bracket along with the main caste. They can put a comma and add a caste to a particular entry where the caste is synonymous with the caste already entered. Or they can add or delete a part of that caste on a territorial basis. This power is endowed to the parliament most certainly, and that, my lord, has been recognized by a lordship. Now,
In fact, 15.4 specifically, Article 15.4 specifically refers to the scheduled castes and scheduled tribes. 16.4 has no reference to scheduled castes and tribes at all. It refers to any backward class of citizens
so your lordship,
who, in the opinion of the state, are inadequately represented in the services of the state. Now, because 16.4 uses that generic expression, any backward class of citizens,
yes,
that will of necessity include the scheduled castes and scheduled
that's
tribes.
right. That's right. But 15.4, your lordships are aware, came later.
Right.
It was by way of a subsequent amendment. So maybe by the first amendment, the my lord framers got a little wiser that why not specify? Why not specify?
Because of that Champakaran Dorai.
That's right. It was a result of Champaka himself. So the effort was to make the intent very clear that when we say backward classes as in 16.4, we mean backward, scheduled caste and scheduled tribe. So that will not have an effect on the merits because the backwardness, my lord, the only thin line that we've seen has been drawn is that backwardness in case of OBCs can be tested, while backwardness in the case of scheduled castes and scheduled tribes is presumed. A state cannot go into the exercise of determination of backwardness as one of the 4 parameters for grant of benefits. Now, my lord, the only word I was struggling with, and I was looking for guidance from your lordships, is this word deemed, my lord. I was discussing with Mr. Farasat also in the morning. It troubles me. Why would the constitution framers use this word deemed? My only explanation was because it is not an exercise in perpetuity. So for that period of time, a deeming fiction is attached to that caste.
So it could be read as deemed to be scheduled caste in relation to that state.
That's what I'm saying. So that is the
Once it
only
is included
explanation I could.
in the list for that state, it will be deemed to be scheduled caste for that particular state
only.
and not for the other state.
Why I say so is that otherwise, normally as we interpret statutes, my lord, your lordships
So that
have
action
far more
committee took-
experience.
Clearly state that in relation to state has been construed
My lord, if we
to
take
a particular state only.
if we take the word deemed out of it, does it change the sense of the article? Then it would be, shall for the purposes of this constitution be scheduled castes in relation to that state or union territory. Why deemed? I could not come up with an explanation, my lord. So therefore, I'm leaving it, my lord, at that because
The reason is that what Article 341 does is it recognizes the sociological existence of castes. Thus, the Article 342 recognizes the sociological existence of tribes.
that's right.
Having done so, it creates an artificial grouping called scheduled castes in 341 and scheduled tribes in 342. Sociologically, there is no scheduled caste as such.
That's what I was saying.
Scheduled caste is an expression which the Constitution has adopted for the conferment of benefits on these communities. So therefore, it uses the expression deemed to highlight that this is really a deeming fiction which has been
We are
created by the
attaching to a particular caste.
The existing sociological grouping consists of castes, which
My lord,
341
my lord has
says
just
and
put it, my lord, just
342.
the way he said.
Or it could be read for the purposes of Article 46. So Article 46 refers to scheduled caste and scheduled tribes.
That's right. No, but
So,
why deemed?
though 15.4 has come subsequently, 46 is from inception.
Right.
It will be deemed to be scheduled caste and 46 provides for special Provisions for scheduled caste, scheduled tribes and vegan sections.
And the caste, my lord, is by birth. Caste is by birth.
Second,
This is the deeming fiction.
Article 341 also contemplates that apart from castes, races or tribes can also be a scheduled tribe, a scheduled caste.
That's right.
It's not only a caste which can be designated as a scheduled caste under 341, but races or tribes can also be designated as scheduled caste because it says specify the castes, races or tribes or parts of groups within castes, races or tribes which shall be designated as scheduled castes. So it recognizes this could be an amorphous group of castes, races, tribes, groups within castes, races or tribes, or parts of castes, races and tribes, which can be designated. Therefore, the reason why they use the word deeming, deemed, is that it is really a fiction which is created for the purpose of this constitution.
That's right. The caste will remain, whether you're in or out.
The caste will remain, the tribe remains, the race remains, those groups within, they don't lose their identity. The identity as caste, races or tribes,
yes.
their sociological identity
Yes.
continues despite their being deemed to be scheduled caste for the purposes of the constitution.
That's right. That's the only explanation I could think of, my lord. And the other thing was, my lord, that if tribes can be scheduled caste, then it would have an overlapping effect which doesn't reconcile with the framing of the constitution. Then why have two different? If tribes can be a part of scheduled castes, then there is a separate provision for tribes in 342.
Right.
Right. Under what article would the president issue an order of a tribe? It can't be either under 341 or 342.
But because 342 doesn't, it does not include caste and race.
It doesn't, but 341 includes a tribe.
It includes a tribe.
So therefore, an overlapping jurisdiction as far as the tribes is concerned.
But it is in recognition of the fact that, you know, tribes and castes were not in that sense watertight compartments all over the country. In some states or in the case of some castes, that caste will not include a tribe at all.
That's
In other states, possibly the constitution took a broader perspective that there may be certain castes which are akin to tribal communities. And therefore, 341, they gave a much broader power.
possibly.
342 says only tribes and tribal communities.
Right. Because there would be some states in India, my lord, where there are no scheduled castes. They only have a tribal community, which is
Like Andaman, Nicobar or...
yes, yes. Northeast, my lord, one or two states where they are classified only under 342. There are no orders of 341 in those states.
There are some states where there's virtually no scheduled tribe.
That's right. That's right. None but Punjab, my lord.
Punjab also.
That's right.
Punjab, Haryana could be.
None.
The reservation was scheduled
Many
tribe were on the
tribes
ground
came and
of...
went from Punjab, my lord.
They were on the ground of geographical handicaps.
That's right.
Whereas 341 scheduled caste is on the account of socio-economic backwardness.
Right. Like in Punjab, my lord, we have Sikri and we have Rai Sikhs. Rai Sikhs were a criminal tribal community, but they're always been categorized as castes. So different headings were given to them, one which has been entered now.
Exactly, that's very important because that shows that though they were essentially tribes, they have been classified as caste for the purpose of Article 341.
That's so therefore, what we have to understand is that the president issues an order which may or may not be brought in perpetuity. We have to understand. Because while issuing the order, what the Constitution very fairly recognizes is that the president, after the issuance of that order, cannot change that order. So, in case there is any error in the order issued, or in case because of the sociological conditions, a caste or a tribe or a race needs to be added to that order, the parliament in its wisdom would do that exercise, which also is challengeable, my lord, on very, very narrow spectrum.
Where is the presidential order here?
Yes, I'm coming to that, my lord. Kindly have the schedule, my lord. Volume 4 is there, my lord, in the... my lords, have the volume 4. It is bookmarked, my lord. And if your lordship would have the second last document, the constitution, my lord, is wrongly typed. It is scheduled caste order, and the third last is scheduled tribes. Kindly have the second last. Page 1371, it starts. Now, what I've just, my lord, stated before your lordships would become clear from here. Lord Sahib 1371?
Yes.
If your lordship would straight away come, my lord, to Part 1, Andhra Pradesh. And if your lordship would have clause 4, that empowers, my lord, the interpretation by saying that any reference in this order to a state or to a district or other territorial division thereof shall be construed as a reference to state, district, or territorial division as constituted on the 1st of May, 1970. So when we see Andhra, my lord, if your lordship would come to 1372, entry number 9, my lord, it has all the contingencies that I was pointing out, my lord. It has a caste called Beda, if your lordship would have it.
The districts of Hyderabad, Rangareddy.
No, first of all, it has Beda, then it has bracket, Budga, which means Budgas are
Yes,
also Bedas.
Right.
Jangam in the districts of, now Jangam is not a separate caste, but it's at the same entry, but only in selective districts of Andhra Pradesh. So therefore, my lord, in line with what the constitution
Beda
says,
Jangam.
that's right.
Caste is Beda Jangam and it could be Budga Jangam also.
That's right.
It has to be read in continuation because
My
otherwise
lord,
there
you're
would
right.
have been
It's Beda Jangam.
otherwise there would have been a comma in between.
That's right, my lord. There's no comma. So
No
it's either interchangeable with Beda or Budga,
So it could be Beda Jangam
Beda
or Budga
Jangam or
Jangam.
Budga Jangam. My lords are right. And in selective districts of Andhra Pradesh. Now your lordship would see, my lord, entry 30. There, they possibly are synonymous castes which have been subsequently added, which are, my lord, Kolupul Valdu, Pambada, Pambanda, and Pambala. Now they are interspread with a comma, meaning thereby that the entry is one, but they may be interchangeable.
Either of them.
Yes. Why, my lord, this is very important is that if in such an entry, a person, my lord, who is born into one of these castes, say for instance, my lord, he is born as a Pambala, but he gets a scheduled caste certificate of Pambada, it will be recognized because it is synonymous and that will not disentitle him.
14 also.
That's right. My lord, that's so right.
Chamar, Mochi.
That's right. Muchi, Chamar Ravidas, Chamar Rohidas. So they are all a part of one entry. When we come to this, it's a caste. Now, why, my lord, 341 was made sacrosanct is, we can just, my lord, refer to this and understand that, as my lords had put it, my lord, tomorrow, a state feels that forget about the scheduled caste status of this caste. It has a population of 12% in my state. If I give them the benefit of scheduled caste by tinkering of the list of under 341, I can get voter friendly. To avoid that mischief, your lordships held, 341, as far as the entry and exit is concerned, is sacrosanct. No state in the federal structure will be able to tinker with the entry and exit or a caste or a part thereof, or a race or a group or a part thereof, while exercising the powers which are not vested in. That was the reason. What Milind and Mullard, the subsequent judgment, say is this: it is not for conferring of benefits at all, which Chinnaiah interprets it to be. It is not a theory of inclusion or exclusion at all. So therefore, Mullard, the principal argument that 341 and 16.4 operate in completely different legislative spheres. The word used there is state. It could either be center or the state government. And they can, in their opinion, confer the benefits which they are enabled to provide under 16 in the manner that they deem fit. The provision of those benefits in the ratio as the state decides is definitely open to judicial review, but it is not tinkering with the list. That is the principal argument on which we propose to Mulad seek the setting aside of Chinnaiah, is that it does not tinker with 341. So now Mulad would have the Punjab list, Mulad, which was an issue in my case. 1381, Mulad. Part 3. Now the statute said Balmiki because Balmiki is synonymous with Chuda and Bhangi at entry 2. And it said Mazhabi, which is interchangeable with Mazhabi Sikh at entry 23.
The
So-
statute uses the word Balmiki and Mazhabi
Mazhabi.
and Mazhabi Sikh.
Mazhabi Sikh. So Mazhabi Sikh and Mazhabi, as per the order, is interchangeable. It's interspread with a comma. And so is Mulad Balmiki with Chuda or Bhangi.
But your act doesn't say so.
Act doesn't say so, Mulad. So
It only
therefore,
uses
we'll have to
one
refer
sentence.
back to the Constitution to say if somebody holds a certificate as a Bhangi, he will be considered for the
Therefore, you
benefit
don't
to
deny
be.
the benefit under 4.5,
That's
4 bracket 5.
Manoj,
to-
all right. Achha.
because they are-
So that is the intent.
But then if you are giving that preferential treatment, it will be only for Balmiki or Balmiki, Chura and Bhangi.
No, we are giving to Balmiki as at entry 2 along with the caste entailed therein, and Mazhabi at entry number 23 with the caste entailed therein interspread by a comma.
Because there, according to the Constitution, has
Yeah.
indicated that these other two communities are also synonymous.
Synonymous and
Or these
interchangeable.
are included in that
Yes.
history. So really, the statute has
Yes.
used only one, Balmiki and Mazhabi Sikh.
That's right. Now, if your lordship would see, Millard, at serial number 37 is a caste called Sikriban,
Yes.
and serial number 39 are two castes which are Mahatam, Raisik. Now, as the proposal of the state was, Millard, that Mahatam is the principal caste. And Sikribans are those people, Millard, who weave rope from jute. So Sikribans and Raisiks, which I was just referring to, who were a criminal community, used to engage in the occupation of weaving of rope and making beds and chairs with the help of that rope. Millard, they were engaged in that vocation. The proposal was that include Mahatam and Raisik with a comma at Sikriban. But the parliament decided, no, we will include them as a separate entity at a separate place, interspread with a comma, but not synonymous with Sikriban.
Sikhiban.
Now, the problem is that a lot of people from Raisik caste and Mahatams had certificates as Sikriban because they actually belong to that caste. In any case, that litigation I'm doing in the High Court, so just sharing it with you a lot. So there, this whole interpretation of milind and comma and a separate entry, we are engaged in the debate, my lord, that whether if historically they are a part of the same community, engaged in the same vocation, which confers the same benefit amongst them as a caste, why should they be given the benefit not from 76, but from 50 when Sikriband was entered as a schedule?
Now, Mr. Advocate, we have seen why jurisprudentially you are saying that Chinnaiah is not a correct, has not interpreted the Constitution correctly, because there's no question of inclusion or exclusion.
That's right.
16.4 is enabling.
Enabling.
341 designation.
That's right.
Now, should we go to the judgments and see?
My lord,
whether there is-
we'll just read quickly 15 and 16, my lord, because that is the whole
Right.
basis of my
There's
argument.
only one distinction between 15.4 and 16.4. 16.4 doesn't use the word any,
Any.
which 15.4 uses. Does that make any difference?
My lord, there are two
Because
things.
15.4 says any, the may provide benefits for any socially and educationally backward class of citizens.
My lord, 15.4 says special provision
Special provision.
and 16.4 says any.
Right. So 15.4 says any.
No, my lord, 15.4 says special provision.
For making any special provision
That's right.
for the
And
advancement of any socially and educationally backward classes of
oh,
citizens.
your lordships are talking about the second any.
Yes, the second.
All right. So, my lord, and there is a difference. If your lordship would have 15,
No,
my
the
lord,
reason
first,
why I'm asking you is,
let's just read 15.4 and 16.4, my lord,
right, let's see 15, 16.4 now.
because the other, my lord, sub-clauses are not relevant. It says nothing in this article or in clause 2 of Article 29 shall prevent the state in this case meaning either the center or the state, from making any special provision for advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. Now, my lord, the word here could have been anything, because instead of or, the word could have been including. It is not including. So when we see the intent, it means that it distinguishes backward
I
classes.
didn't get you.
But if your lordship would see the word between backward classes of citizens or for the scheduled castes and scheduled, it can have two meanings. One, that you can make a law exclusively for backward class of citizens or for scheduled castes and scheduled tribes. But in definite form, it recognizes the distinction between backward classes and scheduled castes and scheduled tribes, because in 16.4, the deeming inclusion of scheduled castes is there in backward class.
So this
Go ahead.
come after Champakaran. So
That's right.
maybe
Champakaran do rahe hai.
he was belonging to scheduled caste.
That's right.
And that GO was challenged wherein the reservation was provided for
The
scheduled caste.
Madras Geo.
Madras GO.
They said, and our court said that you cannot have community-based reservations in admission.
That's right.
That
Therefore,
has
that
got to be taken away.
It should not
what
be communal.
scheduled caste and scheduled tribe is there, but 16.4 was there from inception.
That's right. Now, if your lordship would see,
You know, the only thing, I mean, nothing will turn on this case, but there's a little issue here. 15.4 says from making any special provision, that means any kind of special provision
that's right.
for the advancement of any socially and educationally backward class of citizens. That is, the state can pick out any socially and educationally backward class of citizens, because there is no, it's not like a presidential designation here. Or for the scheduled caste and scheduled tribe. Can the state under 15.4 say that I'm going to make a special provision for only these scheduled castes in my state or these scheduled tribes in my state? Or is it bound to make that special provision that it must apply to all scheduled castes and tribes in the state? Because any in 15.4 qualifies only the former, especially socially and educationally backward classes of citizens, and not scheduled castes and scheduled.
That's right. That's right. So as
Now
far
see,
as the scheduled castes and scheduled tribes are concerned,
you must treat them together as one unit.
exactly, you may make the provision for all, but as far as the internal, my lord, that will come in 16.4, where you can limit, extend, or reserve within that category.
16.4 is even more clear.
Yes, kindly have.
16.4 says, nothing in this article shall prevent the state from making any provision, like there any special provision, any provision for the reservation of appointments or posts in favor of any backward class of citizens.
Any backward class?
So, any backward class of citizens could include
Scheduled castes and scheduled tribes, my lord.
which case the state can conceivably say that, well, though these scheduled castes have been designated in my state, in my opinion, out of them, only these are not adequately represented in my services.
So, my lord, this
Therefore,
recording of
in
opinion,
Maharashtra, there may be 29. In Maharashtra, there'll be X number of scheduled castes. You can say, in my state, the inadequacy of representation applies only to these.
that's right,
Therefore, I'm going to make this provision only for
only
these.
for these. But why 16.4 qualifies it, unlike 15.4, a recording of an opinion is necessary.
Of inadequacy of representation.
Inadequacy of representation, which is not in 15.
It's not there in 15.
So 16.4 as enacted, my lord, in fact places a check and balance on the power of the state when exercised, talking of adequacy of representation. So therefore, those 4 checks and balances,
Really
Lord,
speaking, if you look at your textually, the Punjab legislative measure, which reserves, say, 50%
please, my lord.
for these two communities, Valmikis and Mazhabi
Mazhabi
Sikhs,
Sikhs, yes.
can that also not be justified on the ground that in regard to the relative representation amongst the scheduled castes, these two communities are the least represented within
That's
the
right.
represented group?
That's right. That's right. So it can be either or. One, that they continue to be extremely backward.
And they continue to be the least represented in the
And-
services of the state.
and
which is
or-
impossible and sustainable
Therefore, a more special treatment among the
Yes.
special treatment.
within
Yes.
the.
Yes. That's why I qualified it in the beginning that it
But
can be
your
and or.
collected quantifiable data and all is not before us. We are only
No.
on the broader
So
context.
therefore,
of
my lord,
Chinnaiah.
in scheduled caste, that issue will come up. That issue will come up because when they say backward class, as far as scheduled castes within the backward class is concerned, you cannot apply the test of backwardness.
Right. But you still have to apply the
Inadequacy
test
of
adequacy which
representation,
you have to apply.
yes. 3 tests will still remain. Inadequacy of representation will remain. Then, my lord, efficiency of services as countered by 335 will remain. And, my lord, creamy layer, which is a law in
Journal-
progress.
Journal
Yes.
has applied.
Yes. But that is still work in progress, my lord. But as it stands today, creamy layer will apply to scheduled castes also. Because within the backward classes, as defined by
In the case of the
16.4,
scheduled caste, there's a presumption of backwardness,
Yes.
which there isn't. Which there isn't in the case of the SEBC, especially
Lord,
and education,
yes.
socially and educationally
so
backward. classes.
therefore this debate, my lord, that when there is a presumption of backwardness, but they have attained the forwardness to sever the umbilical cord which attaches them to the definition of backward classes, will they be excluded from the benefit or not? Nobody is saying they will become descheduled. Scheduled castes, they will remain, but they may not be entitled to the benefits which are under 16.4 to be given only to backward classes. So the moment they become forward enough to declassify themselves as backward classes, they will be disentitled to the benefits which flow from 16.4. Because creamy layer is not a caste-based concept. It is an individual concept.
It's an economic concept.
It's an economic, educational, or a sociological. It can be either.
Could be.
Could be either. That caste has come up socially to a very even platform with the other castes, or educationally, most of them are educated, or economically, 5 families of that caste who shifted to the capital town have risen to an extent where, as your lordship not put it, that they have severed the link between backwardness and them. And the moment that link goes, then disentitled for them.
Now, what next, Mr.
Yes,
Advocate?
my lord. Now your lordships would only have one more, my lord, article, which of course is, my lord, 46. Your lordships have seen, my lord. We all know. Then, my lord, 335, which is one of the tests, my lord, which says the claims of members of scheduled castes and scheduled tribes shall be taken into consideration, comma, consistently with the maintenance of efficiency of administration, comma, in making of appointments to the services and posts in connection with the affairs of union or the state. So, my lord, why I say so that this is now relatable to entry 41 in list 2 and entry 61 in, my lord, list 1 and entry 25 in the concurrent list, which pertains to services. Though I don't, in my humble submission, think that there is any direct contact between the controversy at hand and the exercise of power of legislative or executive intent through those entries. I don't think, my lord, that will detain your lordships. But Chinnaiah proceeds on this, that you cannot exercise powers under 41 and 25 being a state, because this would amount to tinkering with the intent of 341. So, my lord, in my humble submission, that argument is misplaced. So I will not dwell on it much. Then your lordship would have, my lord, commission for scheduled castes, which they say that everything has to be routed through them. And then the, my lord, 338A, which is for scheduled tribes. I'm just skipping them, my lord, because they may not be of relevance in this controversy. And 341 we've read, and the lists I've seen. Now, my lord, straight away we can come, my lord, to the judgments. In Chinnaiah, my lord, there are three orders. The first, my lord, which I'll read what has come to your lordships, my lord, is the reference order. Volume 5, my lord.
Volume 5, there are 3 volumes, 5A, 5B, and
Page 1400, my lord, the third last bookmark.
Volume 5.
My lord, just one second. My lord, first your lordship would have 5A, my lord, because that is an order prior in time. Roman 5, small a. In this, the last bookmark, Davinder Singh, my lord, which is the matter before your lordship.
A PDF page, would that?
Page 247 in
778.
volume 5, Roman 5, small a.
You have to put even in 5 it is there.
249. Volume 5, 5A, 249.
Put it in number.
PDF 249, my lord, the last order.
Yeah.
58249.
That's right. PDF 249, running page 247.
There is no 24. Okay. Yes. 582.
This is in Civil Appeal 2317, my lord.
That is Justice Loda, Justice Joseph, and Justice
That's-
Nariman.
This is the order of 2020, my lord. Volume 8, SCC 65.
Though the order, interestingly, is of 2014. Huh?
It's a
I was wondering how a 2020
reported
judgment
in
refers to
2020,
Justice Chief Justice
my lord.
Loda.
Otherwise, an order of 20th of August, my lords may note. The order of 20th of August 2014 by a 3-judge bench.
Yes.
It says, my lord, the learned counsel for the respondents heavily relies upon the Constitution bench decision of E.V. Chinnaiah versus State of AP. On the other hand, the learned additional Solicitor General for the appellants submits that E.V. Chinnaiah has no application on the controversy in hand. Moreover, he submits that E.V. Chinnaiah is not in accord with the 9-judge bench of this court in Indra Sawhney versus Union of India. Having heard the additional Solicitor General and the learned counsel for the parties, we are of the view that E.V. Chinnaiah needs to be revisited in the light of Article 338 of the Constitution of India and inter alia exposition of law in Indra Sawhney. Moreover, the matter also involves interpretation and interplay between 16.1, Article 16.4, Article 338, and Article 341 of the Constitution of India as well. In this view of the matter, we refer the matter for consideration of the above aspects by the larger bench. Let the matter be placed before them. Then comes the order, my lord, which I was earlier pointing out in volume 5, the third last bookmark, my lord. PDF page 1404, my lord.
Volume 5.
This is, my lord, an order of 27th of August 2020.
volume 5 page.
1404.
And in this, my lord, your lordship would come to the concluding part of the judgment.
So 3 placed it before 5, and then 5 placed it before 7.
That's right. Lords, in this judgment, if your lordship would kindly have para 49 on page 140. 1464 PDF. which is in contra to the earlier finding of Chinnaiah, providing a percentage. My Lord Sahib. Yeah,
Yes.
providing a percentage of the reservation within permissible limit is within the power of the state legislatures. It cannot be deprived of its concomitant power to make reasonable classification within the particular classes of scheduled castes, scheduled tribes, and socially and educationally backward classes without depriving others in the list. To achieve the real purpose of reservation, within constitutional dynamics, needy can always be given benefit. Otherwise, it would mean that inequality is being perpetuated within the class if preferential classification is not made, ensuring benefit to all. The subclassification is to achieve the very purpose as envisaged in the original classification itself, and based thereupon evolved the very concept of reservation. Whether the subclassification would be a further extension of principle of the said dynamics is the question to be considered authoritatively by this court. And 52, my lord, they say what exactly is in the mind of the court. The state has competence to grant reservation benefit to the scheduled castes and scheduled tribes in terms of Article 15.4 and 16.4 and also of Article 341.1 and 342.1. It prescribes the extent / percentage of reservation to different classes. The state government can decide the manner and quantum of reservation. As such, the state can also make subclassification when providing reservation to all scheduled castes in the list based on a rationale that would confirm with the very spirit of Article 14, 15, and 16 of the Constitution providing reservation. The state government cannot tamper with the list. It can neither include nor exclude any caste in the list or make an inquiry whether any synonym exists as held in military. And then, my lord, the next paragraph, 51. Coming back, my lord, the scheduled caste. Because of that transient nature of the list, my lord, the scheduled castes as a presidential list are not frozen for all time, and neither they are homogeneous group, as is evident from the vast anthropological and statistical data collected by various commissions. The state law of preferential treatment to a limited extent does not amend the list. It adopts the list as it is. The state law intends to provide reservation for all scheduled castes in a pragmatic manner. Based on statistical data, it distributes the benefits of reservation based on the needs of each schedule. If at all there is an application of mind in 341 for inclusion and exclusion, the application of mind for dissemination of benefits is only under 16.4. Only under 16.4, no other provision. We can go back to Chinnaiah and see what weighed with their lordship's mind to give that judgment and how it has been distinguished, my lord, in Devender Singh reference order. And, my lord, I'll come to the other judgments like Indra Sawhney, my lord, that is more generic in nature. Chinnaiah is, my lord, volume 5, my lord, numerical 5, page 774, my lord. PDF is 778, my lord. It's the sixth bookmark after the index.
PDF 778.
PDF 778.
PDF 778. But the principal judgment is by Justice N. Santosh Hegde on behalf of himself and Justice Varyava and Justice Singh. Lord, what brought this matter to the Supreme Court, my Lord, was the leave granted by the Andhra Pradesh High Court. The issue, my Lord, emanated from a report of a commission headed by Justice Ramachandra Raju. And the scope of this commission was to identify, my Lord, that within the list notified under Article 341 for Andhra Pradesh, please identify who had failed to secure the benefit of reservations provided for scheduled castes in the state in admission to professional colleges and appointment to services in the state. Lord, in pursuance of this report, the Commission, my Lord, opined that within the 15%, my Lord, reservation for backward classes in the state educational institution and services of the state under 15.4 and 16.4, the scheduled caste, my Lord, were primarily apportioned in 4 groups, my Lord, in the following manner. They identified those 4 groups, my Lord, in para 2. For reservation, my Lord, Group A, 1%, Group B, 7%, Group C, 6%, and Group D, 1%, showing that Group A and D were hugely underrepresented. Then, my Lord, an ordinance was issued, and thereafter, which was, my Lord, made an act of 2000. Both were challenged, my Lord, and the matter came to this Honorable Court after the High Court dismissed the challenge by 4:1. Para 5, my Lord, the contentions were, my Lord, the contentions advanced on behalf of the appellants are that the state legislature has no competence to make any law in regard to bifurcation of the presidential list of scheduled castes prepared under Article 34(1) of the Constitution. Therefore, the impugned legislation being one solely meant for subdividing or subgrouping the castes enumerated in the presidential list, the same suffers from lack of legislative competence. It is further submitted that once the castes are put in the presidential list, the said castes become one homogeneous class for all purposes under the Constitution. There could be no further division of the said castes in the scheduled list by any act of the state legislature. His further submission was that in the guise of exercising its legislative competence under entry 41 in list 2 or entry 25 of list 3, the state legislature cannot exercise its legislative power so as to make a law tinkering with the presidential list, because the said entries do not permit any law being made in regard to scheduled castes. In guise of providing opportunity to some of the castes in list of scheduled castes in state cannot invoke entry 41 of list 2 and entry 25 of list 3, divide the scheduled castes according to the Learned Counsel for the impugned enactment does not really deal with the field of legislation contemplated under the said entries, but in reality is targeted to subdivide the scheduled caste. Alternatively, he submitted that the classification or subgrouping made in the state legislature amounted to subclassification or micro-classification of scheduled castes is violative of Article 14 of the Constitution. Then, Lord, 338(9) argument is there in para 7. Lord, we may come to Mr. Venugopal's argument in para 8. On behalf of the respondent, Shri K.K. Venugopal, learned senior counsel appearing for the state who led the argument on behalf of the respondents, contended that Article 341 only empowers the president to specify the castes in the presidential list and the parliament to include or exclude from the specified list any caste or tribe, and beyond that, no further legislative or executive power is vested with the Union or India or Parliament to decide to what extent the castes included in the scheduled caste list should be given the benefit of reservation, which, according to the Learned Counsel, depended upon their degree of backwardness. His further argument is that authority to decide to provide reservation or not, and if yes, then the quantum of reservation to be provided is the exclusive privilege of the state. In that process, the state will have to keep in mind the extent of backwardness of a group, be it other backward classes, scheduled caste, or scheduled tribe. Therefore, having found a class of persons within the scheduled caste as having been deprived of such benefits, the state has the exclusive legislative power to make such grouping for reservation under Article 15(4) and 16(4) of the Constitution, subject, of course, to Article 245, 246 of the Constitution, since in the instant case, there is no allegation that there has been any violation of Article 245, 246. The argument of lack of legislative competence advanced on behalf of the appellant should fail. He further submitted that there is an obligation on the state under Article 16(4) to identify the group of backward class or citizens which, in the opinion of the state, is not adequately represented in the service under the state and make reservation in their favor for such appointments. And under Article 15(4) of the Constitution, there is an obligation on the state to make special provisions for the advancement of scheduled castes and scheduled tribes. And what the state has sought to do under the Impugned Act was only to make such provisions to fulfill the constitutional obligation after due inquiry. Hence, the allegation of violation of Article 14 cannot be sustained. He strongly relied on the findings of fact recorded in Justice Raju Commission report, which, according to him, establishes that some particular groups within the scheduled caste have cornered all the benefits at the cost of others in the said list. Therefore, with a view to see that the benefit of reservation percolates to the weaker of the weakest, it had become necessary to enact the impugned law. The Learned Counsel submitted that by regrouping the castes in the scheduled caste list, there is no reclassification or microclassification as contended by the appellants. Then, my lord, the basis of that report is given, which was on the basis of the Constitutional Assembly debates and so on and so forth. My lords, may straight away now come to questions framed in para 12. Must have it?
Yes.
Whether the Impugned Act is violative of Article 341(2) of the Constitution of India, whether the impugned enactment is constitutionally invalid for the lack of legislative competence, whether the impugned enactment creates subclassification or microclassification of scheduled castes so as to violate Article 14 of the Constitution of India. Though my lord touched on fringes, surprisingly, the interplay of 16(4) and 341 was not even framed as a question. Completely dehoards the constitutional power under 15(4) and 16(4). Because essentially the court proceeds on the conflict between 341 and entry 41 and 25. It was argued, but not, my lord, essentially, I would say, considered as it should have been. I'll now come to the findings starting from para 13. My lord. Yeah, my lord.
Yes.
We will first consider the effect of Article 341 of the Constitution and examine whether the state could, in the guise of providing reservation for the weaker of the weakest, tinker with the presidential list by subdividing the castes mentioned in the presidential list into different groups. Article 341, which is found in Part 16 of the Constitution, refers to special provisions relating to certain classes, which includes the scheduled castes. The article provides that the president may, with respect to any state or union territory, after consultation with the governor by public notification, specify the castes, races, or tribes, or parts of or groups within castes, races, or tribes, which shall, for the purposes of Constitution, be deemed to be scheduled castes in relation to that state or union territory. Now, my lord, here they give their opinion. This indicates that there can only be one list of scheduled castes in relation to a state, and that list should not can only be one, sorry, my lord, and that list should include all specified castes, races or tribes, or part of groups notified in the presidential list. Any exclusion or inclusion from the said list can only be done by the Parliament under 341(2) of the Constitution. In the entire Constitution, wherever reference has been made to scheduled castes, it refers only to the list prepared by the President under Article 341, and there is no reference to any subclassification or division in the said list, except maybe for limited purposes of Article 330, which refers to reservation for seats for scheduled castes in the House of People, which is not applicable to the facts of the case. It is also clear from 341 that except for a limited power of making exclusion or inclusion in the list by an act of Parliament, there is no provision either to subdivide, subclassify, or subgroup these castes which are found in the presidential list of scheduled castes. Therefore, it is clear that the Constitution intended all the castes, including the subcastes, races, and tribes mentioned in the list to be members of one group for the purposes of the Constitution, and this group could not be subdivided for any purpose. A reference to the Constituent Assembly in this regard may be useful at this stage. What they rely upon is, my lord, while discussing 341, if your lordship would have the, my lord, in court part, the page is, my lord, bottom of 780 PDF 794. Para 14, my lord, it forms a part of the object of these two articles, as I stated, was to eliminate the necessity of burdening the Constitution with a long list of scheduled castes and scheduled tribes. It is now proposed that the president, in consultation with the governor or ruler of a state, should have the power to issue a general notification in the Gazette specifying all castes and tribes or groups thereof deemed to be scheduled castes and scheduled tribes for the purposes of privileges which have been defined for them in the Constitution. The only limitation that has been imposed is that once a notification has been issued by the president, which undoubtedly he will be issuing in consultation with and on the advice of the government of each state, thereafter, if any elimination was to be made from the list so notified, or any addition was to be made, that must be made by the Parliament and not the President. The object, now, my lord, this is the italicized part. The object is to eliminate any kind of political factors having a play in the matter of disturbance in the schedule so published by the President. Because they felt that any kind of provision made to a group within the scheduled list will amount to political interference with the list. A discussion that ensued in regard to the framing of this article indicates that there was an attempt on the part of some of the members of the Constituent Assembly to empower the states also to interfere with the list prepared by the President under the said article. As a matter of fact, an amendment to this effect was also moved by Shri Kuldhar Chilla, who, while moving the said amendment, stated that the amendment 201 of list 5 in clause 2 of the proposed article 300B, after the words Parliament may, the words and subject to its decision the state legislature be inserted. Now, my lord, they give what was said in support of that amendment. However, my lord, I think we can skip that, come to para 19. Because eventually they hold that the original proposed article 341 was legislated. Para 19, my lord, this part of the Constituent Assembly debate, coupled with the fact that article 341 makes it clear that the state legislature or its executive has no power of disturbing, term used by Dr. Ambedkar, quote, the presidential list of scheduled castes for the state. It is also clear that articles in part 16 of the Constitution that power of the state to deal with the scheduled castes is totally absent, except to bear in mind the required maintenance of efficiency of administration in making of appointments, which is found in Article 335. Therefore, my lord, this is the finding. Therefore, any executive action or legislative enactment which interferes, disturbs, rearranges, regroups or reclassifies the various castes found in the presidential list will be violative of the scheme of the Constitution and will be violative of Article 341 of the completely per incurium, my lord, 16.4. Then, my lord, they say, we will now consider whether the scheduled caste list prepared by the president under 341 forms one class of homogeneous group, or does it still continue to be a list consisting of different castes, subcastes and tribes, etc. We have earlier noticed the fact that the Constitution has provided for only one list of scheduled castes to be prepared by the president, with a limited power of inclusion and exclusion by the president. The Constitution intended that all castes included in the said schedule would be deemed to be, they say deemed to be one class of persons. That is nowhere in 341. But arguments have been addressed to the contrary, stating that in spite of the presidential list, these castes continue to hold their birthmark and remain to be separated. And individual castes, though put in one list by the president, it is contention of the respondents that by merely including them in the list by the president, these castes do not become a homogeneous group. Therefore, to fulfill the constitutional obligation of providing an opportunity to these castes, more so to the weaker among them, it is permissible to make classification within the class as was made permissible in this regard to other backward classes by the court in the case of Indra Sawhney. We cannot accept this argument for more than one reasons. Then the second finding comes, not, it cannot be denied that all castes included in the presidential list for a state are deemed to be scheduled castes, which means they form a class by themselves. So, my lord, here, that age-old argument, my lord, and an example comes of a fruit chaat and jam. If the intention of the legislature was make it into a jam once they come into the class, then inclusion, exclusion becomes otiose. No? That means after it becomes a jam, you can't take out the apple from it and leave the peach inside. But if the option has been given to the parliament to keep one and take out the other, it remains a fruit chaat and not a jam. But the court proceeded to make it that once they come in, they all merge into one, birthmarks are lost, which in my humble submission is erroneous interpretation of 345. Then, my lord, Chinnaiah J, speaking in the same case with reference to the status of castes included in the presidential list, had this to say, quote, we may clear the clog of Article 16.2 as it stems from a confusion about caste and terminology of scheduled castes and scheduled tribes. This latter expression has been defined in Article 341 and 342. A bare reading brings out the quintessential concept that they, as I see there, are no castes in Hindu fold, but an amalgam of castes, races, groups, tribes, communities, or part thereof, found on investigation to be the lowliest and in need of massive state aid and notified as such by the president. Then, Mulad, they interpret this comment in para 24. According to Justice Krishna Iyer, though there are no castes, races, groups, tribes, communities, or part thereof in Hinduism, the president on investigation, having found some of the communities within the amalgam as being lowliest and in need of massive state aid, included them in one class called the scheduled caste. The sequitur thereof is that scheduled castes are one class for the purposes of. Now, instead of recognizing, my lord, that it's a list of different castes, groups, parts of groups, they say once you come in, you become a part of a list. That list becomes the homogeneous class.
Your contention would be that merely because of their inclusion in the scheduled caste list, their birthmark is not removed. That still remains.
That birthmark will remain because that is the birthmark by which you will eventually be excluded by the parliament, or the benefits to be granted under 16(4) will be to a certain group or groups within that caste. You cannot say that today you are adharmi. The moment you come in the list, this would be a misnomer because that is how the society stands it. The moment you come in the list, you cease being an adharmi, you become a scheduled caste. Can't be. There is nothing called as just a scheduled caste. It's only, my lord, the inclusion in the schedule which makes it in common parlance to be called a scheduled caste. Otherwise, there is no caste known as a scheduled caste.
Yes.
Then, my lord, 26. Thus, from the scheme of the Constitution, Article 341, and above opinions of this court in N.M. Thomas, it is clear that castes once included in the President list form a class by themselves. If they are one class under the Constitution, any division of these classes of persons based on any consideration would amount to tinkering with the presidential. I'll resume.
How long, Mr. Advocate, till now? After this, you'll take
About an hour and a half.
hour and a half.
My lord, this is the first judgment. The only thing is, my lord, once I read those judgments, maybe the repetitive content will not be necessary to be read. I am not going into the, my lord, 63, 64 judgments because everything has eventually crystallized into 5 judgments. So, my lord, this being the first, it will take a little while. I'll try to finish
We did
today.
not go to the pre-NM Thomas judgments.
That's right. N.M. Thomas being very
Thomas,
important.
Thereafter,
Then-
Akhil Bharatiya Club
Yes.
Choice was-
And Indra Sawhney, my lord.
Indra Sawhney really
Of
is
course,
then.
we'll have to see that because eventually what the law has come to be is that what is good for backward classes is good for the scheduled caste. So therefore, that connection will
Chinnaiah
have to
said, well, Indra Sawhney was cited in Chinnaiah, but
That's-
they said, well, that is only for OBCs and
That's
not
right.
for.
That's right. That is the wrong interpretation because it is not. Indra Sawhney itself makes it clear that we are only putting aside the scheduled caste argument because we're not dealing with
We
it.
need to just look at that part.
That
of
those
Indra Sawhney.
paragraphs. Yes.
The
Those
reference order, in fact, sums up all of this.
Yes, they all, like, in fact, extracted the relevant parts of the.
Grateful.
Come back up. और बहुत गर्म नहीं रखना, बर्फ नहीं हो रही बाहर.
Made, please.
Now, which is the judgment you want us to see?
Lord, I was on Chinnaiah, my lord, which is volume 5, my lord, 5th bookmark.
Yes, you got it. The theme is the same, actually, that they say that subclassification, which is permitted in Indra Sawhney for OBCs, is not permissible for SCs because they say it's one homogeneous class.
That's right.
And therefore, once Parliament has designated certain castes or tribes or races as scheduled castes, you cannot further subgroup, subclassify. They use that expression, right? Subdivide, subclassify, or subgroup. That's the theory, really.
One is that.
And your contention is that Parliament's power to designate is very different from the state's power to implement reservations under 16(4). They have not then, therefore, had due regard to the ambit of Article 16(4). That is your submission.
That's the issue of identification, and this is the issue of implementation.
Implementation.
That's right.
They are not considered the interplay between 16(4)
That's right.
and 341.
None at all. In fact, argued by Lord Mr. Venugopal, but not considered at all.
So Article 341 is all about designation,
Identification,
about identity.
stroke inclusion and exclusion of caste. My lord.
Exclusion. Exclusion.
Well, 16.4 is conferring of benefits. On those who are not adequately represented in services.
Which para were you on?
My lord, I was on 26, my lord. I just read 26
Right.
before
Then,
they
I
before
think
they
there
frame the
after
second
31
question.
also. 31 says subclassification is beyond legislative competence under entry 41 of list 2 and entry
Right.
25 of list 3. Then para 38, they say subclassification which is permitted in Indra Sawhney for OBCs is not permissible for SCs who form one class. That's para
Now,
38.
Indra Sawhney does not say so. I'll come to that in a
We'll
bit.
go directly thereafter to Indra Sawhney because
Very good.
and then
That's right, my lord, because
in para 39 and 41 they say the whole theme is this is
my lords
one
have seen the
homogeneous group
second
you
question.
cannot.
Yeah. Second question which they frame in 27. My lords have
Yes.
seen that?
Yes.
Which is on judicial, on legislative competence.
Competence, yes. And they answer that in para 31,
That's
page
right.
798.
That's right. Without examining 16 though, Your Lordship would have, yes, 31, my lord. Last 10 lines are relevant. It is the prerogative of the concerned state. My lords have it. Bottom of page 794.
Plus item E.
Yes. That's right. May I, my lord? It is the prerogative of the state concerned, if it so desires, with an object of providing opportunity of advancement in the society to certain backward classes, which includes the scheduled caste, to reserve certain seats in educational institutions under 15.4 and in public services of the state under 16.4. That part of its constitutional obligation, as stated, has already been fulfilled by the state. Lord, now, this is a very interesting part, Lord. They call this a one-time exercise, which I could not, my lord, conceive how, but they say once you've provided reservation, you've done what you had to do. So if I read it further, my lord, having done so, it is not open to the state to subclassify a class already recognized by the Constitution and allot a portion of the already reserved quota amongst the state-created subclass within the list of scheduled castes. From the discussion herein above, it is clear that primary object of the impugned enactment is to create groups of subcastes in the list of scheduled castes applicable to the state, and in our opinion, apportionment of reservation is only secondary and consequential. So they say the primary objective is creating a subclass, while
Totally, the state may also feel that look, backward classes as a whole are represented in the state adequately, but within the component of backward classes, there are some communities who have no representation at all, and therefore that skewed distribution of benefits has to be corrected.
and Lord, it is not synonymous. It is not synonymous that every backward class would be a scheduled caste.
Right.
Can't be.
Some of them
So-
may be socially and educationally backward.
Yes.
Some of them
So-
may be socially and educationally backward.
Yes, so from amongst the backward classes, those which in your opinion you want to confer the benefit on. It's as simple as
what
that.
they seem to suggest is if you are giving reservations to scheduled castes and scheduled tribes, you must take them as one composite whole.
That's right. That's right.
That's
That-
what the
that seems to be
that
the-
is the logic of the judgment.
That's
The
right.
entirety of the judgment is this way.
That once they've been included in the list,
Then
you
either
cannot
take it or leave it as it is.
Yes, either
You
take
can
the whole
decide not to give reservations at all. But if you give, you must give to everybody.
to
I
everyone
think that's
in
the
equal proportion.
In equal.
That seems to be the intent.
Not
That you
even
cannot.
equal,
not
not
in
in equal proportion.
No, they say you cannot apportion reservation.
Unfortunately.
That is, everybody must have a bite at the entirety of
Entirety of the issue. It should be either 100%
So
or
it
zero.
will go among, as per merit among
Merit.
that, all the category.
I bow, my lord. That is it. That is it. Then, my lord, they say whatever be the object of this subclassification and apportionment of reservation, we think, now, my lord, this is where the, my lord, interpretation of only 41 and 25 comes. My lord may take note. We think that the state cannot claim legislative power to make a law dividing the scheduled caste list of the state by tracing its legislative competence to entry 41 of list 2 or entry 25 of list 3. Therefore, we are of the opinion that in pith and substance, the enactment is not a law governing the field of education or the field of state public services. Here, 16.4 should have found its part. They say that
Yes.
power is being traced only to entries.
I think we've dealt enough
of
with
got
this.
it,
Now
Lord.
let's go straight
Your
to,
lordships have got it, yes.
to Indra Sawhney, I think, because
My lord, your lordships have seen question 3, my lord, para 32 and 33.
32 and 33.
32, they frame the next
They
question.
follow Trilokinath Kosa, that micro classifications are not
Yes,
permissible.
but there they consider a very important issue, that is it violative of 14? They say that whether it would stand the test of Article 14, then, my lord, considering Khosa's judgment,
There actually Kosa, if you see page 416, what happened was, Classitum B,
that's right.
if in this case the government had prescribed that only those degree holders who had secured over 70% marks could become chief engineers, and those with 60% alone would be eligible by be SEs, or that foreign degrees would be preferred, we would have anticipated avoided. I think there what happened was that they were going by the birth marks.
That's right.
And the argument of the finding of our court is once you enter service, whether you're a direct recruit, whether you're a diploma holder or a degree holder, once you enter service, then your birth marks are erased. Then you become a
Then you
member
will
of
be
service.
governed by the rules under 309.
Yes,
If you are a DSP, for promotion to SP, it doesn't matter how you came.
right.
You have to compete with the others and get through your quota. If there is for direct recruitment or promotion, it will govern you. Your lordships are absolutely right. My lord, they answer this, if your lordship would only have one line. The third question in para 37. We have already held that the members of scheduled caste form a class by themselves, and any further classification would be impermissible while applying the principle of reservation. Then, my lord, Indra Sawhney's finding comes in para 38, my lord, on behalf of the respondents. My lord, have it.
That we need not.
I'll go to
we'll
Indra
go
Sawhney
straight
and
to
show-
Indra Sawhney.
I will show that Indra Sawhney never decided that in scheduled caste subclassification should not be done. Then more backwardness, end of para 41.
The thing is, we may read only one sentence there, Classitum D, because that very judgment itself has specifically held that subdivision of other backward classes is not applicable to scheduled castes and scheduled tribes.
It has not. That is what I will show.
We just that
That
part
is what I'll
just-
show.
we Just see
Yes.
Indra Sawhney.
For other purposes, it has deliberated, but for this purpose, it has never held it. Para 41, your lordships have seen, my lord.
Class as a whole. Basically.
That's right. With last 5 lines, they say that
I
it is
think that we
difficult
can
to.
leave it there. I think it's the same now.
I think so.
Same thing.
Justice Sema's judgment is on the same lines, my lord, than Justice Sinha's judgment concurring.
Mr. Advocate General, as Mr. Shankar Narayan said in the morning, The reference order of penned by Justice Arun Mishra
That's right.
contains now an elaborate extraction of all the judgments in Indra Sawhney. So maybe we can go directly to the reference orders. We'll find everything at one place.
Everything would be there. Yes.
We don't flip pages then.
Where, my lord, in Indra Sawhney, it was a judgment, my lord, where Justice B.P. Jeevan Reddy is given the majority opinion. So that majority opinion, my lord, on behalf of him and 4 other judges, my lord, that we'll just need to see the gist of it as to what exactly have they had.
All right.
So then, my lord, I'll skip this judgment. Your
We'll now
lordships may have a look at it.
dealt with the judge. Where is Indra Sawhney? Do you want to go?
Yes, my lord, Indra Sawhney is a part of this compilation.
Arun Mishra's judgment, whatever.
The original.
What, volume 5 page?
My lord, it starts at page 190, PDF page 194, my lord. Let me just say at the outset, my lord, the exceptions which they talk of are only on 2 issues. One is on presumption of backwardness, which they opine on, and then creamy layer. These 2, your lordships may note, they do not opine on subclassification. We can come to, my lord, page 688, PDF 692, my lord.
Yes.
My lord, para 780, my lord. Identification of backward class of citizens.
Which page is that?
My lord, this is the centum E, page 692 PDF, internal page 715 of the judgment in SEC, my lord.
Yes.
Para starts with, now we may turn.
Yes.
Now we may turn to the identification of backward class of citizens. How do you go about it? Where do you begin? Is the method to vary from state to state, region to region, from rural to urban? What do you do in case of religions where caste system is not prevailing? What about other classes, groups, and communities which do not wear the label of caste? Are the people living adjacent to ceasefire line in Jammu and Kashmir or hilly or inaccessible regions to be surveyed and identified as backward classes for the purpose of Article 16(4)? And so on and so forth are many questions asked of us. We shall answer them, but our answers will necessarily deal with generalities of the situation and not with problems or issues of peripheral nature, which are peculiar to the particular state, region, or district. Each and every situation cannot be visualized and answered. That we must leave to the appropriate authorities appointed to identify. We can only lay down general guidelines. Then 781, at the outset, we may state that for the purposes of this discussion, not for the purposes of identification, we keep aside the scheduled tribes and scheduled castes, bracket, since they are admittedly included within the backward classes, bracket close, except to remark that backward classes contemplated by 16(4) do comprise some castes, for it cannot be denied that scheduled castes include quite a few castes. So for the purposes of identification, they keep aside scheduled caste, saying that there is a presumption. Then, my lord, para 782 would be slightly relevant. Coming to the question of Muslims, I had shown that to your lordships, my lord, from the order. Now, the second exception, my lord, is just below in para 792, my lord. It starts from, my lord, running page 695, para 790, PDF 699, my lord.
Paragraph 792,
Para 790,
0.
means test and creamy layer. That is the heading of the, my lord, discussion. Subclause D. Means test in this discussion, my lords have it, signifies imposition of an income limit for the purpose of excluding persons from backward class whose income is above the said limit. This submission is very often referred to as the creamy layer argument. Petitioners submit that some members of the designated backward classes are highly advanced socially as well as economically and educationally. So, my lord, they are talking about what is the creamy layer principle, and in 792 on page 697, I'll read, my lord, the umbilical cord argument, my lord. In our opinion, it is not a question of permissibility or desirability of such test, but one of proper and more appropriate identification of a class, a backward class. The very concept of a class denotes a number of persons having certain common traits which distinguish them from others. In a backward class under clause 4 of Article 16, if the connecting link is the social backwardness, it should broadly be the same in a given class. If some of the members are far too advanced socially, which in the context necessarily means economically and may also mean educationally, then the connecting thread between them and the remaining class snaps. The connecting thread between, they would be misfits in the class. After excluding them alone, would the class be a compact class? In fact, such excluding them alone, such exclusion benefits the truly backward. Difficulty, however, lies in drawing the line. How and where to draw the line? For while drawing the line, it should be ensured that it does not result in taking away with one hand what it gives by the other. The basis of exclusion should not be merely economic, unless, of course, the economic advancement is so high that it necessarily means social advancement. Let us illustrate the point. A member of backward class, say a member of a carpenter caste, goes to Middle East and works there as a carpenter. If you take his annual income in rupees, it would be fairly high from the Indian standard. Is he to be excluded from the backward class? Are his children in India to be deprived of the benefit of 16.4? Situation may, however, be different. If he rises so high economically as to become, say, a factory owner himself, in such a situation, his social status also rises. He himself would be in a position to provide employment to others. So, my lord, they are going on a very subjective satisfaction of at which stage the cord between backwardness and the individual breaks. Now, my lord, I'll straight away go to the last 10 lines of this paragraph, where the individual, my lord, argument ends. It starts with, it is then argued for the respondent. Recitum B, my lord, on page 698. Yeah, my lord, it is then argued. It is then argued for the respondents that one swallow does not make the summer, and that merely because a few members of the caste or class become socially advanced, the class or caste as such does not cease to be backward. It is pointed out that clause 4 of Article 16 aims at group backwardness and not individual backwardness. While we agree that socially advanced members will make a class a truly backward class and would more appropriately serve the purpose and object of clause 4. This discussion, kindly note this discussion is confined to other backward classes only and has no relevance in the case of scheduled tribes and scheduled. So this discussion is on creamy layer, whether the individual income or the income of the class as a whole and the parameters and factors which would define as to whether the cord and the thread between the class and the individual and its backwardness has snapped or not. So these are the only two parameters where they exclude the discussion on scheduled caste. Otherwise, Indra Sawhney nowhere excludes scheduled caste for the purposes of subclassification. So, my lord, in fact, if your lordship would see on subclassification, they positively, my lord, if your lordship would come straight away to 801, my lord, the question number 5, it is answered on page 702, PDF 706, my lord. Where the question is framed whether backward classes can be further divided into backward and more backward categories. Does have it?
Yes.
And this backward, my lord, includes SC/ST, because they say in Balaji it was held that subclassification made by order between backward classes and more backward classes does not appear to be justified under Article 15(4). Article 15(4) authorizes special provisions being made for the really backward classes. In introducing two categories of backward classes, what the impugned order in substance purports to do is to devise measures for the benefit of all the classes of citizens who are less advanced compared to the most advanced classes in the state. And that, in our opinion, is not the scope of 15(4). The result of method adopted by the impugned order is that nearly 90% of the population of the state is treated as backward, and that illustrates how the order in fact divides the population of the state into most advanced and the rest, and puts latter into two categories of backward and more backward. The classification of the two categories therefore is not warranted by Article 15(4). This is quote from Balaji. Then they hold the correctness of this holding is questioned before us by the counsel for the respondents. It is submitted that in principle there is no justification for the said holding. It is submitted that even among backward classes, there are some who are more backward than the others, and that the backwardness is not and cannot be uniform throughout the country, nor even within the state. In support of this contention, the respondents rely upon observation of Chinnaiah Reddy J. in Vasant Kumar, where the learned judge said, we do not see why on principle there cannot be classification into backward classes and more backward classes, if both classes are not merely a little behind, but far behind the most advanced classes. In fact, such a classification would be necessarily help the more backward classes. Otherwise, those of the backward classes who might be a little more advanced than the more backward classes might walk away with all the seats. Then in para 802, they say, we are of the opinion that there is no constitutional or legal bar. This was a specific question which fell from your lordships. To the state categorizing the backward classes as backward and more backward. We are not saying that it ought to be done. We are concerned with the question, if the state makes such categorization, whether it would be invalid. We think not. Then they give the example of Mandal Commission, which may not be so relevant. Because here they are comparing, two castes. Like in Andhra Pradesh, they are comparing goldsmiths and vades. which who are stone cutters, my lord, to be a part of the backward class, but goldsmiths will always be more affluent than the stone cutters, my lord. So there, if a distinguishing factor is made between both of these, there is a rationale which is supported. Basically, my lord, the issue is that that exercise, as and when done, has to be taken to be whether it is done with the object sought to be achieved in mind, whether it is a reasonable classification or not. Now, 803, my lords, may I have. There is another way of looking at this issue. Article 16.4 recognizes only one class, which backward class of citizens. It does not speak separately of scheduled castes and scheduled tribes, as does Article 15.4. Even so, it is beyond controversy that scheduled castes and scheduled tribes are also included in the expression backward class of citizens, and that separate reservations can be provided in their favor. It is well accepted phenomena throughout the country. What is the logic behind it? It is that if scheduled castes and scheduled tribes and other backward classes are lumped together, OBCs will take away all the vacancies, leaving scheduled castes and scheduled tribes high and dry. The same logic also warrants categorization as between the more backward and backward. We do not mean to say, we may reiterate, that this
But
should be done.
There's little confusion over here. Does that really apply to a subclassification of the scheduled castes and tribes, or is it really referring to only the subclassification of the OBCs, other than the?
My submission would be both. Because as your
I
lordship
don't know
correctly
actually
said,
whether that may not be a correct reading of Indra Sawhney.
Lords in fact said that what is the logic? If
Indra
you
Sawhney
use,
said the reservation of OBCs only for consideration. Because regard to reservation of OBCs.
Therefore,
That's
they
right.
said right up front that we are leaving aside the issue of SCs and STs. Yeah.
they leave that aside only on two issues, my lord, creamy layer and identification of backwardness. When they discuss backward within the backward, they do not say we are not talking about scheduled castes.
It appears that that whole discussion in the context of the socially and educationally backward classes, the OBCs, really.
My lord, whether or not it's a positive mandate, I leave it to your lordships to decide, because this judgment would most certainly be binding upon all of us. The only thing is there is no bar. They clearly and
That's a
categorically
separate
say,
argument altogether. But to say that this expressly recognizes that there can be a subclassification among scheduled castes, may not be, that was not the issue really that they dealt with.
not really, but it recognizes the logic. If there is a gap between the disadvantaged and the most disadvantaged, it's a reason enough for classification. That is a rational criteria. That's what Indra Sawhney holds, that backward and more backward is a rational criteria.
And it is permissible in law.
It's permissible in law. Also, nothing in law bars it. Nothing in law prohibits it. So if the state, that is what I said in the beginning, there's no mandate to do it. But if the state chooses to do it, there's nothing against it.
Question is already answered here.
That's right.
What remains?
That's right.
End of the matter. 9 judges have decided.
Yeah, it's binding on us.
Then, my lord, we can straight away come to Nagaraj, my lord, or Thomas. Because that is, my lord, a judgment which is very clear and categoric. And an emphatic reiteration of the principle. This is also, my lord, in volume 5. PDF. That is Nagaraj. Thomas. Page 23, my lord. Yes. PDF page 27.
Of the same volume.
That's right.
This is
No,
coupled
this
here,
was a 7-judge bench which was considering.
So 20. That is Thomas.
Thomas.
Yes, Thomas. Yes, 1976 to SEC 7.
We want to. go to
Not just
data.
a few, just a couple of paragraphs which are relevant, because otherwise, my lord, it reiterates the issue. Because it talks specifically of 16.1 and 16.4 interplay, my lord. Because we just come straight away to para 24 to 28, my lord. Prison.
Start from
High Court here is decided only on the basis non-suited you, or really held against you only on the basis of Chinnaiah.
Quite right.
So if we come to the conclusion, of course, we are here to hear the other side, that Chinnaiah is wrongly decided, this will have to go to the High Court for any other challenges. Right? Any other challenges which are there to the statute? Otherwise, we will be deciding issues like adequate representation, whatever
But
other,
otherwise-
challenges there are.
But what I can also suggest is that once your lordship set aside that judgment on the basis that Chinnaiah itself
We
has
can
been
send
set
it to
aside
3 judges.
and leave the question of law open, my lord. If somebody challenges in a flesh litigation, we will deal with it, my lord.
But what were the challenges there before the High Court?
Primarily this, my lord, that there's a 5-judge bench
Other
which is
than that, there
already
was
there.
other ground.
No fresh grounds were
No
taken. Mr.
ground for
Sen.
judicial review of
The
that.
grounds were same which were otherwise reiterated in Chinnaiah.
The original petitioners before the High Court are represented here. So we'll see what is the nature of their challenge.
Yes,
If
yes.
Chinnaiah was the fundamental
Only challenge.
basis of the petition, then we can conclude it here, one
Yeah.
way or the other after hearing.
That's what I'm saying.
And then if somebody else wants to challenge it, file a petition there. Why should we?
Moroj may grant them the liberty if any additional issues arise other than Chinnaiah. I'm sure, my lord, there's no bar in challenging them because that would be a fresh challenge.
Unless they say they have raised other valid challenges which
For
were
which-
not adjudicated, then we have to restore the petition.
For which they would want to revive their petition. Yes. That's right.
Because one thing is clear, the High Court has gone only
Only
on
on that.
That's right.
The other way is that we restore it to a 2-judge bench. Judge bench will decide all the other questions, but they lose the right. Whoever one person loses the right of appeal.
There's no challenge with regard to quantifiable data and all that.
No, my lord, not to my knowledge.
So there can't be because in Punjab, scheduled caste are 38%, my lord, and the reservation is only 25%. So there can't be quantifiable data to that extent, my lord.
Why?
Why?
That is in the statute, my lord. 25% in direct recruitment.
No, but there
And-
could be at least, look, there will be data at 2 levels. One, are the scheduled castes as a group in Punjab adequately represented in the services of the state? That's one. 2, within the group of scheduled castes, is there, not proportionate, but is there a fair representation to the Mazhabi Sikhs and the Balmikis? The
With-
government
with
may have
respect-
data on that. They would have collected data.
My lord, if
Obviously,
the
without that, they wouldn't have come up with this
population correlation
legislation.
is there, that has to be 38%, my lord.
They means who?
The Mazhabis and
Right.
what is the population ratio
39%.
amongst the scheduled castes?
Yes,
Amongst the scheduled castes,
yes,
they constitute 39%.
yes. And yet their representation
39%.
is very, very minuscule. And the posts they occupy are of scavengers.
And the
In
what is the
government
total?
municipalities, that's all.
What is the total representation of scheduled castes in Punjab?
25% is the limit. Malak.
38%.
What is the total population?
About
38%.
33%.
38%, man. There is no scheduled tribe
It's
there,
about
my lord.
33%.
So all are claimed
33%.
together as scheduled caste.
And the
38%.
Mazhabi Sikhs and the Balmikis constitute about
Of that.
39% or 33%.
And Malak, although there are 39 castes mentioned, but I've given that data, Malak, from government records. Some of these castes are only Malak 30 people, 70 people, 100 people, 200. So although these are 2 castes, but they represent 39%. And on the other side, Malak 2 or 3 castes represent Malak a much larger number, represent about 43% people, but they are occupying 81% of the post. They are the main people who are left out, whom the other side represents. So I will give that data. Place that.
We need not go into that question.
Look,
There is a quantifiable data.
actually, this doesn't arise. We are dealing with, it's a bench of 7 judges. We are dealing with the validity of the decision, the correctness of the decision in Chinnaiah.
That's what I was submitting, my lord.
We will not go beyond that. And Mr. Swaroop, Manu Swaroop, we shouldn't be going into things which are not argued
That's
before
why I
the High
said
Court.
numericals.
We
There
should
is
inform
one-
the subject matter, the reference by 3, 5.
Only out of curiosity, we asked.
Yeah, we just said generally we.
That's not fair, kindly consider.
Please rest assured, we'll not rest our decision on that.
It did not give very adequate advice. I'm not going into that for the reason that other people may have different data as they are monitoring. but the state data is a 2020 data of the year 2020. Their first notification came, as your lordships observed, in 1975.
75, yes.
Their act came in 2006. They put on record data of 2020. Again, unverified, although there's a commission, constitutional
That
commission.
will have to
now.
be argued at the appropriate.
Yes.
What data was there when you passed the act? Therefore, that will impact upon the reservations for that period between the act and 2020 when
I
they.
would therefore submit
They're
basically, you have the
not going into that.
One of the arguments which we would address also here, that the concept of creamy layer has no applicability here for the simple reason, the difference between the scheduled caste and the downtrodden scheduled caste is not much. The creamy, they are not far ahead than end. One is earning little, one is earning 10 rupees, other is earning 5 rupees. The whole proposition is there as a fallacy.
That has not been accepted
which
in
the
Journal.
state is projecting it.
Justice Nariman's judgment in Journal specifically doesn't argue it.
So
In fact, the argument before that constitution bench was the concept of creamy layer has no application to the scheduled caste, scheduled tribe, and that has been rejected by that is not a
that
question
is a
before us.
general proposition, but when we come to the factual aspect, when we see what the scheduled caste is earning and what the downtrodden scheduled caste is earning, your lordship will say that they are not far ahead. They have just brought.
You can't decide it on a priori basis like that.
That's your. That we would be arguing and supported by that. That under what circumstances the. Yeah.
Mr. Advocate General, now what more? What next now?
Please, Mulad. Mulad, I was in para 24, Mulad, of Thomas.
Thomas, yes.
Page 45, PDF 49. They're just short paragraphs, Mulad. I'll quickly go through them. Discrimination is the essence, Mulad Sahib.
Yes.
This is Justice Ray's opinion. Discrimination is the essence of classification. Equality is violated if it rests on unreasonable basis. The concept of equality has an inherent limitation arising from the very nature of constitutional guarantee. Those who are similarly circumstanced are entitled to an equal treatment. Equality is amongst equals. Classification is, therefore, to be founded on substantial differences which distinguish persons grouped together from those left out of the groups, and such differential attributes must bear a just and rational relation to the object sought to be achieved. So, my lord, further in para 31 on page 47, PDF 51, my lord. Here also they talk of equality, my lord, amongst equals. They say the rule of parity is the equal treatment of equals in equal circumstances. The rule of differentiation is enacting laws differentiating between different persons or things in different circumstances. The circumstances which govern one set of persons or objects may not necessarily be the same as those governing another set of persons or objects, so that the question of unequal treatment does not really arise between persons governed by different.
To that, it's not settled. Equal treatments to unequal.
That's right. That's settled law. Need not much labor on it. So they will also come to para 44, Mulad, about preference, Mulad. PDF 54, our constitution. Our constitution aims at equality of status and opportunity for all citizens, including those who are socially, economically, and educationally backward. The claims of members of backward classes require adequate representation in legislative and executive bodies. If members of scheduled castes and tribes who are said by this code to be backward classes can maintain minimum necessary requirement of administrative efficiency, not only representation, but also preference may be given to them to enforce equality and to eliminate inequality. Article 15.4 and 16.4 bring out the position of backward class to merit equality. Special provisions are to be made for advancement of backward classes and reservations of appointment and post for them to secure adequate representation. These provisions will bring out the content of equality guaranteed by Article 14, 15.1 and 16.1. The basic concept of equality is equality of opportunity for appointment, preferential treatment for members of backward classes, with due regard to administrative efficiency alone can mean equality of opportunity for all citizens. Equality under Article 16 could not have a different context from equality under Article 14. Equality of opportunity for unequals can only mean aggravation of inequality. Equality of opportunity admits discrimination with reason and prohibits discrimination without reason. Discrimination with reason means rational classification for differential treatment having nexus to the constitutionally permissible object. Preferential representation for backward classes and services with due regard to administrative efficiency is permissible object, and backward classes are a rational classification recognized by Constitution. Therefore, differential treatment and standards of selection are within the scope of equality. Not basically, the judgment proceeds on this standard, that differentiation for the purposes of achieving the constitutional objective is permissible, which I am citing, my lord, to basically support my argument that if within the class,
Unequal treatment to unequals,
yes. So if there are unequals even within the backward classes,
to bring them equal.
that's right. Eventually, my lord, if the government is holding the hands of people who are socially and economically backward, there can absolutely be no adversarial claim of that very class holding the hand of people who are further downtrodden. Basically, with the eventual idea of bringing everybody, if not equal, but adequately represented. That is the basic substance, my lord. Then, my lord, the next judgment, we can come straight away to my lord Nagaraj. PDF 1336, my lord. Pagination 1332.
One.
1336, my lord, PDF. Here, my lord, the subclassification was discussed and upheld pertaining specifically to scheduled castes and scheduled tribes, my lord. The main judgment Justice Kapadia's judgment. Well, may kindly have page 1398 straight away, my lord. PDF.
Page
1398 PDF, my lord. Here, my lord, Indra Sawhney, as your lordship, my lord, wanting to clarify, that is discussed as to on what purposes and what is the further interpretation given. May I, my lord?
Yes.
In Indra Sawhney, the equality which was protected by the rule of 50% was by balancing the rights of general category vis-a-vis the rights of BCs and block consisting of OBCs, SCs and STs. On the other hand, in the present case, the question which we are required to answer is whether within the egalitarian equality indicated by Article 16.4, the subclassification in favor of SCs and STs is a principle constitutionally valid. So this is specifically framed as a question. Article 16.4a is inspired by the observations in Indra Sawhney by the paras 802 and 803, in which this court has unequivocally observed that in order to avoid lumping of OBCs, SCs, and STs, which would make OBCs take away all the vacancies, leaving SCs and STs high and dry, the state concerned was entitled to categorize and subclassify SCs and STs on one hand, vis-a-vis OBCs on the other hand. But then 802 and 803 are reproduced. Then 115, my lords, may have. Therefore, while judging the width and ambit of 16.4a, we must ascertain whether subclassification is permissible under the Constitution. The subclassification between OBCs on one hand and SCs and STs on the other is held to be constitutionally permissible in Indra Sawhney. In the said judgment, it has been held that state could make such subclassification with SCs and STs vis-a-vis OBCs It refers to subclassification within the egalitarian equality by de para 802 and 803. Therefore, Article 16(4)(a) follows the line suggested by this court in Indra Sawhney. In Indra Sawhney, on the other hand, by de para 829, this court has struck a balance between formal equality and egalitarian equality by laying down the rule of 50% ceiling limit for entire BCs as a class apart vis-a-vis GC. Therefore, in our view, equality is a concept is retained even under Article 16(4)(a), which is carved out of Article 16(4). As stated above, Article 14 enables classification. A classification must be founded on intelligible differentia, which distinguishes those who are grouped together from the others. The differentia must have a rational relation to the object sought to be achieved by law under challenge. In Indra Sawhney, an opinion was expressed by this court by day 802 that there is no constitutional or legal bar to making of classification. Under 16(4)(b is also an enabling provision. It seeks to make classification on the basis of differentia between current vacancies and carry forward vacancies. In case of Article 16(4)(b, we must keep in mind that following the judgment in R.K. Sabharwal, the concept of post-based roster is introduced. Consequently, specific slots for OBCs, SCs, and STs, as well as GC, have to be maintained in the roster. Well, then say, therefore, by article, 2 lines below, 16(4)(b, a classification is made between current vacancies on one hand and carry forward backlog vacancies on the other. Article 16(4)(b is a direct consequence of the judgment of this court in R.K. Sabharwal, by which the concept of post-based roster is introduced. Therefore, in our view, 16(4)(a and 16(4)(b form a composite part of the scheme envisaged. Therefore, in our view, Articles so together form a part of the same scheme. As stated above, 16(4)(a, 16(4)(b, both inspired by observations of the Supreme Court in Indra Sawhney and R.K. Sabharwal, they have nexus with Articles 17 and 46 of the Constitution. Therefore, we uphold the classification envisaged by Article 16(4)(a and 16(4)(b. The impugned constitutional amendments, therefore, do not obliterate equality. So, here they've extended that principle of Indra Sawhney of BCs to SCs and STs. Can I take your lordship to 16(4)(a and 4)(b, my lord? Just for the sake of reference. Lord, may kindly have the Constitution, my lord. (4)(a) reads, my lord. (4)(a), my lord. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of posts and services under the state in favor of scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. So, my lord, here specifically, the state is endowed with the power
To make reservations in promotion.
to make reservations for scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented. Not backward classes,
Only
even
the
within
state-
the scheduled caste and
That
scheduled
too not
tribes.
adequately represented. There is
Yes.
therefore quantifiable data.
So therefore, my lord, in scheduled castes also, there may be some which are adequately represented, some which may not be totally adequately represented. So they can be carved out under 4A and then, my lord, for consequential seniority under 4B.
Which other judgment are we done now?
Yes, my lord, Nagraj is done, my lord. We can come straight away to Devendra, my lord. Now, your lordship was saying is the latter reference order, my lord.
This is Arun Vishwas.
Yes. which is 2010. Page 1400, my lord, PDF
1404,
1404.
2028 SCC, page 1.
That's right.
Now you have taken us through the basic judgments. You don't have to go through the reference.
That's
also.
right. I think this discusses everything in detail, my lord. I'll
Yes.
just come to the relevant parts of it.
It basically extracts all the judgments.
My lord, may come straight away to my lord, page 1416, which is 1420 PDF, my lord.
One four.
1420 PDF, running 1416.
Hello, Nagaraj.
The opinion of Justice Arun Mishra, this was a unanimous verdict, my lord, authored by him. A bench of 3 judges. May I, my lord?
Bench of 5.
5. This is 5.
Reference by 3,
That's right. my lord. Reference by 3.
decided by 5.
That's right. Not a simpliciter reference, your lordship said correctly put it. It gives details, my lord, as to why they feel that Chinnaiah needs to be
It
revisited.
answers all those 3 questions.
Yes, that's right.
They made recorded all your arguments here.
Exactly.
And held in your favor.
That benefit I surely had, my lord. Para 2, they frame the questions, my lord.
Para 35 at page 1458. So before that, it's basically quotations.
Have your lordship seen para 7, my lord, where the submissions are noted and then the conclusion? Or we can come straight away to the findings, my lord.
We can go straight to the finding. First sentence of para 35, they formulate the question whether it amounts to an inclusion or exclusion
That's right.
subclassification.
In fact, not a reference is made to Justice Sinha's opinion from Chinnaiah in para 20. Page 1431 PDF, my lord. Your lordship could just have that.
Yeah, Mr. Shankaran, you're right. It's para 33 placitum D. They say the preferential treatment would not tantamount to excluding other classes as total deprivation caused to any of the castes in the list of scheduled castes. It is a case of classification to provide benefit to all and to those deprived of the benefit of reservation, being the poorest of the poor. They raise the question whether the action based on intelligible differentia to trickle down the benefit can be said to be violative of Articles 14 and 16, and whether subclassification can be said to be an act of inclusion or exclusion, particularly when various reports indicate that there is inequality inter se various castes included in the list of scheduled castes. They do not constitute homogeneous class, have been relied upon.
In fact, my lord, in this, they opine that Jarnail Singh lays down the fact that creamy layer is applicable to SC/ST in para 27. Your lordships. After discussing Ashok Kumar,
Then they say in para 44 again. The caste or group or subgroup continued exactly as before in the list. It is only those persons within that group or subgroup who have come out of the untouchability or backwardness by virtue of belonging to the creamy layer who are excluded from the benefit of reservation. The million-dollar question is how to trickle down the benefit to the bottom rung. Reports indicate that benefit is being usurped by those class who have come up and adequately represented. It's clear caste, occupation, poverty are interwoven. State cannot be deprived of the power to take care of the qualitative and quantitative differences between different classes to make ameliorative measures.
para 46 also, your lordship may have, there is a cry.
Yes, para 46 is important.
Para 46, there is a cry and caste struggle within the reserved class as benefit of reservation in services and education is being enjoyed. Who are doing better hereditary occupation? The scavenger class given the name of Valmikis remains more or less where it was, and so on. Disparity between scheduled castes is writ large from various reports. The subclassification was made under section 4, subclause 5 of the Punjab Act to ensure that benefit of the reservation percolate down to the deprived section and do not remain on paper, and to provide benefit to all and give them equal treatment, whether it is violative of Article 14. In our opinion, it would be permissible on rational basis to make such subclassification to provide benefit to all to bring equality, and it would not amount to exclusion from the list, as no class oblique caste is deprived of reservation in totality. In case the benefit, which is meant for the emancipation of all the castes included in the list of scheduled castes, is permitted to be usurped by few castes who are adequately represented, have advanced and belong to the creamy layer, then it would tantamount to creating inequality, whereas in case of hungry, every person is required to be fed and provided bread. The entire basket of fruits cannot be given to the mighty at the cost of the others under the guise of forming a homogeneous class. The Constitution is an effective tool of social reformation. Removal of inequalities intends to wipe off tears from every eye. The social realities cannot be ignored and overlooked, while the Constitution aims at comprehensive removal of disparities. The very purpose of providing reservation is to take care of disparities. The Constitution takes care of inequalities. There are unequals within the list of scheduled castes, scheduled tribes, and socially and educationally backward classes. Various reports indicate that scheduled castes and scheduled tribes do not constitute a homogeneous group. The aspiration of equal treatment of the lowest strata, to whom the fruits of reservation have not effectively reached, remains a dream. At the same time, various castes by large remain where they were, and they remain unequals. Are they destined to carry their backwardness till eternity? Then they answer it in 48 and 49. The state's obligation is to undertake the emancipation of deprived section of community and eradicate inequalities. When the reservation creates inequalities within the reserved class itself, it is required to be taken care of by the state.
Yes, right. You can leave the judgment. Thank you, Mr. Advocate General. I think we are wrapped up now.
Please, Lord, I think that's more or less
Thank you so much, Mr. Advocate.
grateful.
Mr. Farasat, what ground are you going to cover now?
I have now 3 submissions. I'll just formulate them and then I'll go straight into them. Because the first submission is that Chinnaiah has certain internal contradictions because it's proceeded on the basis that Article 341 is solely for the purpose of reservations alone.
It's for the purposes of this constitution.
That's correct. So, my lords, the way Chinnaiah proceeds, absolutely, I'm so grateful to my lord the Chief Justice. The way Chinnaiah proceeds, it in fact says that.
All right, you can formulate and then.
Yeah, so that's the first formulation.
Yeah.
Well, the second submission is that Article 342A has now been introduced in the Constitution, and that
Article
342 capital A has been introduced in the Constitution, and that, read with your lordship's judgment in Jaishi Patil, completely negates the fundamental logic of Chinnaiah. Now, the third submission is that insofar as efficiency in service, that is Article 335 is concerned, that is something when read in the context of Constitution, in fact supports subclassification. It does not negate subclassification because Chinnaiah, because Article 335, the requirement of efficiency in administration of the government, mandates or requires subclassification. Just before I go into each of the points, my lords, there are, if I may submit, there are broadly two approaches your lordships have followed. My lords, this is at the risk of slight oversimplification in matters of reservation. Plus, one is, if I may articulate it, the cautious approach, where the court is primarily concerned with preventing misuse of reservation, ensuring that it goes to the right people, ensuring that hopefully in a certain amount of time it comes to an end. Plus, the order in reference which the learned Advocate General just read is, in my respectful submission, example of that approach. And, my lords, there is another approach, which is the deepening approach, which is, my lords, the court is primarily concerned with how to deepen the impact of reservation, all the groups. And that is the primary concern which the court is really concerned with. Plus, my respectful submission is that the question of subclassification within scheduled castes and scheduled tribes, irrespective of which of the approaches the court takes, leads to the same conclusion.
That is the first approach you say?
Plus, I said it's a cautious approach, where the court is more concerned with the formal mechanisms of reservation and preventing its misuse.
Yes.
In the second, my lord, the court's emphasis is more on deepening the impact of reservation. If I may say so, my lord, the Chief Justice's judgment in Pavitra is an example of the deepening approach. My submission is that irrespective of which of those two approaches the court takes, both of them lead to the same conclusion. That is, subclassification is not just constitutional, but possibly desirable and necessary. Plus, second, it is clear that the principles which apply in the context of reservation versus non-reservation can be mirrored in the context of subclassification within scheduled castes, no doubt about it. Because the same principles can be mirrored, like my lord the Chief Justice pointed out in the morning. However, my lord, in my submission with one difference, and that is that when we are dealing with scheduled castes, we are dealing with the weak and the weaker. There is no forward group, because that distinction is of some essence. Because, my lords, this subclassification, either in the way we formulate our submissions or, my lords, the legislature or the court engages, should not be used to beat the parent category of scheduled class itself, because that is also essential. So really, we are discussing not a forward, backward, or more forward and backward within backward. We are discussing weak and weaker, my lord. So with that distinction, my lords, I will just broadly go into my first submission. Your lordships will straight away have Chinnaiah para 41. And that is, my lords, internal page 418, volume 5, and running page 798. Volume 5, PDF, page 802. begins at 801 bottom. This is Justice Hegde speaking for the majority. The conglomeration of castes given in the presidential order, in our opinion, should be considered representing a class as a whole. The contrary of
Reading
para 41, 41.
Page 01.
Clause have it. Clause just
page 801.
That's right. Plus PDF 801.
PDF 801, otherwise it is 797.
That's right. I'm grateful. The conglomeration of castes given in its presidential order, in our opinion, should be considered as representing a class as a whole. The contrary approach of the High Court, in our opinion, was not correct. The very fact that a legal fiction has been created is itself suggestive of the fact that a legislature of a state cannot take any action which would be contrary to or inconsistent therewith. The very idea of placing different castes or tribes or groups or parts thereof in a state as a conglomeration by way of a deeming definition clearly suggests that they are not to be subdivided or subclassified further. If a class within a class of members of the scheduled caste is created, the same would amount to tinkering with the list. Such subclassification would be violative of 14 of the Constitution. It may be true, as has been observed by the High Court, that the caste system has got stuck up in the society, but with a view to do away with the evil effect thereof, a legislation which does not answer the constitutionality cannot be upheld. It is also difficult to agree with the High Court that for the purpose of identifying backwardness, a further inquiry can be made by appointing a commission as to who amongst the members of scheduled caste is more backward. Now, this is important. If benefits of reservation are not percolating to them equitably, measures should be taken to see that they are given such adequate or additional training so as to enable them to compete with the others, but the same would not mean that in the process of rationalizing the reservation to the scheduled caste, the constitutional mandate of 14, 15, and 16 be violated. So what the court is suggesting, and this becomes more explicit in Justice Sinha's opinion, which I'll just read now, is that you can take other measures for them, but not reservation. That is the suggestion. And that will become explicit. Your lordships will now have para 114, which is at page 819 PDF.
890.
819, my lords. Para 114, it begins under the heading, what is the remedy? So, after holding it to be unconstitutional,
Page 819.
What is the remedy?
that's right. There is one practical aspect of the matter which may not also be lost sight of. The chart produced before us clearly shows that the members belonging to Reli and Adi Andhra are hardly educated. What are necessary in the situation was to provide to them scholarship, hostel facilities, special coaching, etc., so that they may be brought on the same platform with the members of the other scheduled tribes, namely Madiga and Mala, if not with the OBCs. It is not in dispute that the members belonging to Reli are hardly educated. Only 2% of members of the said community have studied in secondary school. And then there is some discussion, etc. So what the court is suggesting as a remedy is that you give other forms of affirmative action only to the subcategory. Plus, that, in my respectful submission, is a contradiction in terms of interpretation of 341 itself. Because 341 is scheduled caste for the purposes of this constitution. It doesn't say for the purposes of reservation alone. So my submission is, in their imagination, the court, the Chinnaiah court has assumed that 341 is really for reservation. You can do these other things which will not hit 341. But in fact, those very things which the court suggests will equally be hit by the interpretation of 341.
In fact, they are supporting your argument here.
In a way, yes, Manoj. So what I'm really saying is that if what the court suggests is possible.
And identified them and what we dealt with it.
Correct. So Manoj,
accept the position. Backward among the backward.
Yes.
Correct. So factually, they concede, the court says that factually the problem exists. And it says
but the reservation is not the remedy.
Reservation is not the constitutional remedy because it's not permissible on account of my interpretation of 341. But at the same time, the court says there is other remedy. What I'm saying is either both remedies are available to me or none are available to me.
They couldn't have said that you take this and not the other.
That's right. And
Because
Manoj,
the purpose of Article 341 cuts across the Constitution.
that's right.
It's not-
And Manoj, that will become evident when your lordship looks at Article 46. Because for the purposes of this constitution, of course, reservation under 15.4 and 16.4 is one aspect. Now just have a look at 46.4. I know your lordships are aware of it, but just for a moment, have a look at it. Promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. The state shall promote with special care the educational and economic interests of the weaker sections of the people, and in particular of the scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation.
It's actually a postulate that the scheduled castes and scheduled tribes are deemed by the Constitution to be weaker sections.
I'm grateful. Absolutely. And Manoj, this 46 is couched in such broad language that any affirmative action will be covered under this for the scheduled caste and scheduled. Scholarships, the kind of examples the court gives in Chinnaiah will be squarely covered by 46. And if my lord now has 15.4 for a moment, because those measures are in effect protected by 15.4. A government can give scholarship to only a subcategory or a group only upon protection from 15.4. So 46 and 15.4 are really two sides of the same coin.
All right.
So Manoj, that is my submission, and therefore the logic of Chinnaiah, if applied fully, in fact, is in my favor. Manoj, I'm grateful to Justice Nath for that. Manoj, my second submission is that there is a new provision introduced in 2018. And Manoj, that is 342A. Your lordships will just have that provision first. It is similar but not identical to 342. And something that's why your lordships were then required to interpret it in one judgment. (342A) Part 1. The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof by public notification, specify the socially and educationally backward classes in the central list. Plus, this is actually amended. Specify the bracketed portion your lordships will leave and be deemed to be socially and educationally backward in relation to the state or union territory as the case may be. Plus, initially, there was no reference to central list.
Initially read the socially and educationally backward classes, which shall for the purposes of this Constitution.
That's right. So there was no reference to central list in the initial 2018 amendment. But clause 2, Parliament may by law include in or exclude from central list of socially and educationally backward classes specified in a notification issued under clause 1 any socially and educationally backward class, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. So clause 342A as it originally stood, part 1 of it was almost identical to part 1 or clause 1 of 342.
Right.
But insofar as clause 2 was there was the word central list, which is different even as it originally stood from 342. Therefore, the question which arose, Malaz, in Jayashree Patil's case is what is the real intent of the original amendment to 2018 amendment? Because the word central list is there. So is it taking away the power of the states to actually,
yes,
to actually identify the OBCs?
Yes.
Because Malaz, this is a provision which for the first time is introduced in 2018. So the power to identify was all, unlike the SC/STs, the power even to identify was always with the states for OBCs. Yes. Now this provision is introduced 342A, and the question was, is that power lost?
The power of the states.
Power of the states to identify.
Yes.
And the court says, yes, it is lost in Jayashree Patil. By reading, the question was whether 2 will control 1, clause 2, central list will control 1, or 1 will control clause 2, really speaking. And the court came to the conclusion that the word central list in 2
Yes.
will be controlled by 1, and therefore the states have lost the power. So although the word central list is there in 342, in Jayashree Patil, your lordship says, in effect, 342 capital A is identical to 342. That is, from here on, for all purposes, not just central list, it will be only the president and thereafter the parliament which will identify the caste. Because that is the majority in Jayashree Patil. You know, there's two judges dissenting also, but that's the majority, 3:2.
Also then held that till such time as the government identifies, the state list will continue. So the central government has not so far identified. So the state list continues.
Oh, I see.
As a matter of fact, that also needs to be looked at again because the entire federal structure is disturbed because the states don't have any power anymore.
It came in 2021.
21.
That
But the 21 amendment was before Jayashree Patil, right?
No, after. As a response to Jayashree Patil. No, I'm just coming to that.
Jayashree Patil was which year?
20, Jayashree Patil is 2020. Plus the amendment is a response to Jayashree Patil's finding. I'll place that. Yes. Now my lords will just first have, now the submission I'm making for the court's consideration is this, that even in Jayashree Patil, where the court interpreted 342A to be identical to 342, even though the word central list were present in the second part, despite that says that for all other purposes, that is subclassification, etc., nothing changes. So here you have now for the SEBCs, a structure like 342, but the states are permitted to subclassify. Plus, that's my submission. I'll just make that good by taking your lordship through the judge. So now on Jayashree Patil, your lordships will straight away have page 1462 is where it begins. And your lordships will have para 162, which is at PDF 1607.
Further, at page number?
This is at page number 1607 PDF, 1603 on the right hand side. Parliament through the 102nd Amendment clearly intended that the existing legal regime for identification of communities as SC and ST and for inclusion in the list of SC and STs under Article 341 and 342, which had hitherto existed, ought to be replicated in relation to the identification of SEBCs. To achieve that, Parliament inserted Article 338B, which is a mirror image of Article 338 and 338A. The tasks assigned to the new Commission for Backward Class, which is envisioned as a multi-member commission, are radically different from the duties which were assigned by Parliament to the National Commission for Backward Caste Act. Under Section 9 of the erstwhile NCBC Act, which was repealed just before the commencement of the 102nd Amendment, the NCBC was to examine requests for inclusion of any class of citizens as backward classes in the list, and advice of the Commission was ordinarily binding upon the central government. Section 11 provided for a periodic revision of lists. As noticed by Ashok Bhushan J, Article 338B envisions a larger role for the new commission. This commission not only advises the central government, but also the states. It is impossible to read Article 338B in isolation from the pre-existing pari materia provisions. It must be interpreted in the light of the two provisions which had existed all this while. 338.
Justice Bhatt also concurred with Justice Bhushan.
No, Justice Bhushan was in dissent. So he is
right, with Justice Nazir.
Yes. So on this point, the majority of this judgment was Justice Bhatt, Justice Nageshwar Rao, and Justice Nazir. And the other two judges are really in a dissent.
On this point.
On this. For this matter, this is the only point in this judgment which my submission is relevant.
Relevant for this.
Yes. Now, my lords, those provisions clearly contemplate the same consultative role of the commission, etc. I'm not going to read that. Your lordships will now come to 166. I'll read it. My learned friend wants to read. This commission not only advises the central government but also the states. It is impossible to read Article 338B in isolation from the pre-existing pari materia provisions. It must be interpreted in the light of other two provisions which had existed all this while, Article 338 and 338A. Those provisions clearly contemplate the same consultative role with the Commission on policy matters of the central government as well as the state government. This is evident from clause 9 of these articles. Thus, the Commission under Article 338B is not only assigned a constitutional role, but is also expected to act as an expert and engage with experts in the determination of the communities. 338B5 uses the term SEBC no less than on 6 occasions. The expression also occurs in Article 338B9. Thus, for the purpose of the Constitution, the Commission newly established under 338B, that is NCBC, shall be the only body to whom both the central government and the state government have to turn in all matters of policy. Necessarily, the question of matters of policy would also include identification of caste or communities at backward classes. Now, my lords will have 166. And I'll just read the first part, my lord. I don't want to trouble your lordships with too many paras, and I'll just formulate the point. Given the weight of such precedents, which to this court, giving full effect to the newly added provision by adopting the literal meaning in the definition set out in the Constitution, as well as in the amendments to the definition clause, and all of which was noticed the changes brought about through amendments and gave them plain effect, it is difficult to accept that the power of amendment of the Constitution, in accordance with the special procedure set out in 368, was used to bring about cosmetic changes conferring constitutional status. So, there were two arguments. One argument was that this 342A, if I may use the word slightly funnily worded in terms of difference from 342, was only to confer a constitutional status on the status quo which was legally already present. Right. And the other argument was that no, this actually brings it in line with 342, states lose the power to identify. The court says it is not cosmetic, it is substantive, and the states lose the power to identify. Now, despite that, what the courts hold is what I am canvassing to the court, my lord. Your lordships will have para 168. And below plus item E. Yet one must be mindful of a crucial fact, which is that the task for making special provisions under Article 15 and for making reservations under Article 64 extends to the states. The power exercised by the president in relation to every state vis-a-vis SC/ST has been smooth, and by all accounts, there has been no resentment or friction. Once the community or the caste concerned is reflected in the list of one or the other state union territory, the extent of benefits to be provided to members of such community is a matter that lies entirely in the state's domain. So identification the president does exclusively and the parliament, but the nature of benefits will be rolled out is in that state's exclusive domain. Now, my lords will have para 182. Is at my lords page 1616 PDF. This court is also of the opinion that the change brought about by the 102nd Amendment, especially Article 342A, is only with respect to the process of identification of SEBCs and their list. That is the real meaning of 342 as well. Necessarily, the power to frame policies and legislations with regard to all other matters, that is welfare schemes for SEBCs, setting up of institutions, grants, scholarship, extent of reservation, and special provisions under 15.4, 15.5, and 16.4 are entirely with the state government in relation to its institutions and its public services, including services under the agencies and corporations and companies controlled by the state government. In other words, the extent of reservation, the kind of benefits, the quantum of scholarship, the number of schools which are to be specially provided under 15.4 or any other beneficial or welfare scheme which is conceivable under 15.4 can all be achieved by the state through its legislative and executive powers. These powers would include making suggestions and collecting data, if necessary, through statutory commissions for making recommendations towards inclusion and exclusion of caste and communities. So, Malas, that's the second part on even on inclusion and exclusion I can recommend. But once included or excluded, with that category, what is to be done? The entire gamut of things which can be done is still with the state exclusively. So, Malas, this is Chinnaiah goes this way, Malas. This judgment, in my respectful submission, goes the opposite way. It identifies that there are two different things, which is the submission we are trying to make to the court. Now, my lords, finally, your lordships will have para 194.5.5. That is at page 1619. And PDF page 1623 plus 194.5.5. The state's power to make reservations in favor of particular communities or castes, the quantum of reservation, the nature of benefit, and the kind of reservations, and all other matters falling within the ambit of 15x16, except with respect to identification of SEBCs, remains undisturbed. Remains undisturbed, except identification. What is the sequitur of this? In SEBCs, Malas, there is subclassification already. Your lordships have seen Indra Sawhney.
Yes.
Now here you have a provision which has been read by this court to be identical to 341. And except identification, everything else is left undisturbed. Therefore, Malas, that subclassification power also has been left undisturbed. Now, Malas, what does the amendment do? I'll just conclude this point with that amendment. The amendment came as a response to this judgment, Malas. And that is clause 3. Your lordships will have clause 3. Notwithstanding anything contained in clauses 1 and 2, every state or union territory may by law prepare and maintain for its own purpose a list of socially and educationally backward classes, entries in which may be different from central list. Plus, this restores the power to identify to the state. Clause 3. I'll read it again. Notwithstanding anything contained in clause 1 and 2, every state or UT may by law prepare and maintain for its own purpose a list of SEBCs. So this restores the power to identify, which clause 1 and 2 as interpreted by Jayashree Patil did not provide.
Brought on 15th of September 21.
Correct. But Malas, my submission is this.
The same amendment also amended clause 1
by bringing the central list.
That's right. Also, that's right. I'm grateful, Malas. That was brought in as well.
Specify the socially and educationally backward classes in the central list, which for the purpose of the central government. Those words came in.
So that's true, Malas. So it restores that position. But so what it does, it restores the position vis-a-vis OBCs pre the amendment and pre Jayashree Patil. That's what it does. But my submission is when the court took it as equal to 342, that is what Jayashree Patil is prior to the amendment. Even at that stage, the court says everything else
is left to the
That's
state.
right. And Malas, that is in contradistinction and complete contrast to the approach Chinnaiah has taken.
Right.
Malas, that's the second submission. Plus, my third and final submission.
Of course, both are judgments of 5 judges.
I will be, and since your lordships are in 7, we will commend, Malas, the approach of this judgment to your lordships as opposed to Chinnaiah. Plus, the third submission is that insofar as Article 335 is concerned, Malas, normally it is seen, although Malas, some judgments of your lordships in recent times have undone that it is a restriction on the principle of reservation. I'll just read 335. Claims of scheduled caste and scheduled tribes to services and post. The claims of the members of the scheduled caste and the scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in making appointments in the union or state. Consistent with maintenance of efficiency in administration. Plus, in my respectful submission, this provision actually is not a provision which is a limiting principle of reservation, certainly not in government service. And I'll try to make it good. It is in fact an enhancing principle for reservation and subcategorization both.
I think I've dealt with this.
In Pavitra, Manoj, I'll place those paras. I'll place. Your lordships have dealt with it Manoj, directly in Pavitra. Plus, but before I go to Pavitra, Manoj, just one submission. What is this is about Manoj, efficiency is contextual.
Yes.
Something which may be efficient in one context will cease to be efficient in another context. Now, just one example.
It depends on how you define efficiency. If you define efficiency in an inclusive sense,
yes,
by the inclusion of people who have hitherto been excluded from governance, then it promotes efficiency. Also, putting people from the marginalized communities in important positions of responsibility itself is receptive to the needs of those communities and to the need for inclusion as a social doctrine. Therefore, it's not really something which detracts from efficiency.
Absolutely. And in addition,
because the postulate of the Constitution is not that people who belong to the marginalized groups are inefficient and those who belong to the other groups are efficient, and therefore having more of the reserved categories will detract from efficiencies. To the contrary.
Exactly. Maloj, that's there. And in addition, Maloj, this is
efficiency. It is consistent with the need to maintain efficiency in administration.
Yes, and efficiency in government administration is what is government administration? Maloj, government, what is government? What is government's business is the people. Plus, government's business is the people. So when we are talking about efficiency in government administration, diversity by itself promotes efficiency. Because that's my submission for the court's consideration. Efficiency in government administration will necessarily necessitate existence of diversity. Just example, we came across example. In Norway, they recently took a child of an Indian couple because the children were being fed by the hands, through hands by the parents. Because that is basically, they don't have the understanding, diverse enough administration to understand this is a cultural but hygienic practice. They assume that just because you are using hands, they put the child in foster care. So, Malaj, efficiency in administration will require a certain amount of diversity because otherwise you will have disastrous consequences of this kind of example. There can be many other examples given in our context. So, diversity is essential component of efficiency, especially in government administration, because you're dealing with a diverse public. You're not dealing with just a section. You're not government of A or B. You're government of everybody.
All right.
And Maloj, I'll just place the paras in Pavitra.
Where is Pavitra?
Volume 5A. Maloj, it begins, your lordship will have page 111 PDF, page 111 PDF, para 124. The substantive para 124. Page 111 PDF.
Yes.
The substantive part of 335 contains a mandate, a requirement to take into consideration the claim of SCs and STs in making appointments to services and posts in connection with the affairs of the union or of a state. Consideration is much broader in its ambit than reservation. The consideration of their claims to appointment is to be in a manner consistent with maintaining the efficiency of administration. The proviso specifically protects provisions in favor of SC/ST for relaxing, qualifying in any examination, lowering the standard, or reservation in a matter of promotion. Reservation is encompassed within the special provision, but the universe of the latter is wider. I just have 126. The lordships have written a lot of paras. I'll just focus on the ones which assist us the most. Para 126. The Constitution does not define what the framers meant by the phrase efficiency of administration. Article 335 cannot be construed on the basis of a stereotypical assumption that roster point promos drawn from the SC/STs are not efficient or that efficiency is reduced by appointing them. This is stereotypical because it masks deep-rooted social prejudice. The benchmark for the efficiency of administration is not some disembodied abstract ideal measured by the performance of a qualified open category candidate. Efficiency of administration in the affairs of the union or of a state must be defined in an inclusive sense where diverse segments of a society find representation as a true aspiration of governance by and for the people. If, as we hold, the Constitution mandates realization of substantive equality in the engagement of the fundamental rights with the directive principles, inclusions together with the recognition of plurality and diversity of the nation constitutes a valid constitutional basis for defining efficiency. Our benchmarks will define our outcomes. If this benchmark of efficiency is grounded in exclusion, it will produce a pattern of governance which is skewed against the marginalized. If this benchmark of efficiency is grounded in equal access, our outcomes will reflect the commitment of Constitution to produce a just social order. Otherwise, our past will haunt the inability of a society to move away from being deeply unequal to one which is founded on liberty and fraternity. Hence, while interpreting 335, it is necessary to liberate the concept of efficiency from a one-sided approach, which ignores the need for the positive effects of the inclusion of diverse segments of society on the efficiency of administration of the union or of a state. Establishing the position of SCs and STs as worthy participants in affairs of governance is intrinsic to an equal citizenship. Equal citizenship recognizes governance which is inclusive, but also ensures that these segments of our society, which have suffered in history, prejudice, etc., are the real voice in governance. Since inclusion is inseparable from a well-governed society, there in our no antithesis between maintaining of efficiency and considering the claims of SC/ST. This formulation, I respectfully submit, should be adopted by your lordships in the 7-judge combination, so that 335 is not seen as a limiting principle to reservation, but as a principle to expand. Just like firstly, 16.4 was seen as an exception to 16.1 in the initial jurisprudence of this court, and then your lordships have held that 16.4 is actually a facet of 16.1. Plus, similarly, this is also, in fact, a facet, and therefore, insofar as Chinnaiah, which are two places.
Indra Sawhney also rejects the argument that reservation is anti-merit.
That's right. That's right. Plus, merit plus is what they call in one of these books nurtured talent. If somebody doesn't get to, and something called natural talent.
I think I've also considered that here.
Yes,
and how benchmarks and
Yes, the lordships have given a very detailed this thing. I'm not reading all of it, but the principle really is that 335 is not efficiency in governance is not about efficiency for a particular group or defined in a void. It's not rocket science, particularly in government. When you're dealing with people, efficiency has to mean how does a government really deal with all the people? And if I may submit, we really don't know what real efficiency is because real equality really has not arrived in our government. Plus, we will see the true meaning of 335 when we have a substantive equality, and then we'll see what real efficiency is. That's the true meaning of 335. Plus, so insofar as Chinnaiah in some paragraph says that this subclassification will also be contrary to the principle of efficiency, either contrary to principle of efficiency for normal classification or for subclassification. That's my third submission. I'll just there is I will not quote it, but we used to read in our NCRT books Gandhiji's talisman that whatever you do, you must think of the weakest person. And does that help that weakest person, and all your doubts will disappear. This is one of those instances where what the state is doing is actually helping the weakest person. I'm grateful.
Thank you. Mr. Sibal, we start tomorrow morning. We're almost on the anvil of 4 o'clock.
Box put this side of the lawyers. I've got the time 2 minutes of. Then see it.
Yes.
What we'll do is now, we've substantially covered a lot of ground, we've covered a lot of substantial ground. We'll conclude the submissions of this side by lunchtime tomorrow. So that then we can ask the others to, the other side to argue. So if, we'd like to wrap up tomorrow because, I mean, what they have to say after this. We'll conclude the.
Yes, I think so.
So just as you leave, maybe the others who have to follow can, between yourselves, ration the time for the people who are appearing.
It's not an issue. Organize that.